Committee, who also happens to be chair of the Conference of Committee Chairs, the body which will look in detail at the Article 50 negotiations for the European Parliament. So I give the floor now to my colleague Cecilia Wickstrom. Cecilia.
Thank you very much. Dear colleagues, ladies and gentlemen, the Petitions Committee of the European Parliament, for which I'm the chair, have received a lot of petitions in recent months, weeks and months, one could say. People who are afraid for their small businesses, people who are unable to seek a job or get a new mortgage, people afraid of being separated from their families, or who are even in fear of leaving the UK on holiday in case they would experience issues with visas or re-entry. These peoples are anxious and frightened about the future. The Brexit decision has created uncertainty for millions of people, and a citizens' concern about the future must therefore be our top priority, and issues related to citizens' rights solved first of all, before anything else can be negotiated. This has to be sorted out. One of the rights concerned by Brexit is the right to petition, a right which is open to any EU citizen and or any natural or legal person that is resident or has registered office in a member state. It is with this right that the citizens is offered a full role to play in democratic life. This is reflected in the role of the European Parliament and its prerogative to respond to citizens' concerns. It contributes not only to the reinforcement and to the consolidation of a representative democracy, but also enhances the Parliament itself in the eyes of citizens. The UK petitions represented in 2016 6% of the total number of received petitions. In previous years, this number was usually between 5 to 6 of the total. It has now risen to 10.6% in 2016, which is an increase created by the number of petitions sent by individual citizens, individual young people, middle-aged people, old people, people like you and myself, concerned by Brexit. In 2017, we have received additional petitions, additional 22 petitions already, from a total of 137 petitions on Brexit. These petitions reflect the immense concern of citizens regarding the EU's and possibly the UK's negotiating positions. The petitions are concerned by different things. First, the implementation of EU citizenship rights, the involuntary loss of EU citizenship, and the possibility to preserve those rights for those UK citizens that choose to keep them along with their EU citizenship. Secondly, the protection of EU citizenship and corresponding rights, such as the right to free movement, access to the labour market, right to be covered by EU legislation on protection of workers, etc. Thirdly, the applications for citizenship of the Union for those UK nationals residing in other member states. Furthermore, we can never allow Brexit to split families. Families that exist thanks to the European free movement. We must also remember that every citizen, besides national citizenship, also has a European citizenship, which is based on freedom and humanism, which in its spirit forms an essential part of European identity. By putting the citizens first, we will protect this central value also in a future where Britain and the EU are no longer belonging to the same family. I hope that this hearing now will contribute to providing some answers to the petitioners concerned and to all citizens concerned including the 3 million citizens of other member states living and residing in the UK and the 1.2 million British citizens currently living in other member states of the European Union. This is not a matter of party politics or political strategy. This is an issue that concerns real people. This is about basic human values, about common decency. This is about treating people the way that you yourself would want to be treated. Only by putting citizens first can we, at the end, achieve a fair result at the end. I wish you also, as my colleague, very welcome to this hearing, and I look forward to an interesting exchange of views with all of you. And now I'm passing the floor to my co-chair, Mrs. Renate Weber, Vice Chair in the Employment Committee. Please, the floor is yours.
Thank you very much, Cecilia. Dear co-chairs, dear guests, dear colleagues and participants, I'm here today representing the chair of the Employment Committee to this hearing, which is of a particular importance from the employment perspective. I strongly believe that when we're thinking about Brexit consequences, there is no greater concern than the fate of the EU citizens who study, work, settle or visit the United Kingdom, and of those British citizens who work or live in the EU 27 member states. In fact, every single day I receive questions from Romanian citizens who work or study in the UK about what will happen to them after Brexit, and I am sure that other colleagues have to answer to similar questions from their fellow citizens. Today, when a citizen travels or moves to another member state to settle permanently or work temporarily or study or for holidays, there are bridges and interactions between national security systems to guarantee citizens uninterrupted access to all kinds of benefits regarding sickness, maternity, paternity, family issues, old age, unemployment. This is a cornerstone for citizens' mobility and rights, and it is at the heart of the European project. In this respect, Brexit will have an impact on the daily life of millions of EU citizens. Please allow me to give you some figures. More than 21 million tourists from the EU 27 member states visit the United Kingdom annually. 27 EU frontier or cross-border persons work in the United Kingdom. More than 50,000 are posted workers. 125,000 students from the EU 27 member states study in the United Kingdom. 120,000 persons from the EU 27 member states are seeking jobs in the United Kingdom. On all these persons, as well as on the retired Europeans who live in the UK, Brexit will have a direct impact, and the way the issue of acquired rights will be tackled during the negotiations will make a difference to their lives. Of course, we have to consider also the indirect impact on the lives of their family members in the UK or in the EU countries. They are facing great challenges, and so do we. It is for the first time we experience such a complex situation. Therefore, I believe that the success of the negotiations will depend on the trust the member states should put in the minds and in the heads of EU negotiators. It is a time when member states must prove solidarity, must not adventure into bilateral talks and negotiations, but rely on our European institutions' capacity to protect EU citizens. I'm looking forward to hear the experts' insight on this. Thank you, Chair.
Thank you, Renata. The Constitutional Affairs Committee is going to play a particular role in these Brexit negotiations for the Parliament, and Danuta Hübner, the chair of that committee, is going to make some brief opening remarks. Danuta.
Thank you very much, Claudia, and I would like to join my colleague Claudia and other colleagues in welcoming you wholeheartedly to this discussion. I also think that it is extremely important that parliamentary committees cooperate as much as possible on cross-cutting issues in the framework of the Brexit process, and such an issue is exactly the one that we are going to discuss today, with the rights of citizens. That's why I am so grateful to the colleagues from the three committees for opening also the door for the Constitutional Affairs Committee. We are responsible at the end of the process for the consent procedure of the European Parliament, but we have been also involved over the last year in many debates, hearings related to the citizens' rights. Last week we listened to Professor Poyares Maduro, who is the former general advocate in the European Court of Justice, also on those issues. So I'm extremely grateful that we can also listen and be here with you today. I believe that meeting like this is an extremely important broad platform for the debate on Brexit-related challenges. But this meeting is exceptional, I think, also because we are going to hear also from representatives of the citizens who are mostly affected, and that's, I think, a huge value added of this meeting. I would like to say maybe a few words with regard to the perspective of the AFCO committee on the issue. The protection of individual rights is within the EU legal order. It's a very important element and governed by fundamental constitutional principles of the European Union. And that's why the protection of the citizens' rights in the framework of the Brexit process is paramount and is the core of the Union's concerns. The response we will give to this fundamental issue during the negotiations will have impact on the lives of millions of citizens of the European Union, and on also what I would like to underline, it's also extremely important for our reflection on the evolution of the Union constitutional legal order in the future and the European citizenship as well. So I think we must, without doubt, find the right responses to the challenges ahead of us in this regard. And we also know that it's not going to be easy, and I'm sure that Guy Verhofstadt will talk about that, because we are here standing at a particular confluence of very complex, both legal and politically extremely sensitive issues, for which additionally there is no previous script. And that's why I think that is why during the negotiations we must aim at ensuring a single framework, guaranteeing reciprocal, balanced and mutually enforceable protection of the rights of the European citizens in the UK and also UK citizens in the EU following the withdrawal of the UK. And it will be up to both negotiating parties to ultimately agree on and determine the scope of the protection of citizens' rights. And it is, in our view, important from the very outset to clearly define what is the constitutional and legal framework within which we must act to address the issues at stake. And we must ensure that the political process of the negotiations is correctly informed and conducted from the EU constitutional and legal point of view. And I think the role of European Parliament here is also extremely important. We must also know whether there are any limits to the political discretion margin in negotiating the issue of that importance, like the rights of citizens in the context of Article 50. But we must also be clear on the question whether there are any minimum requirements in terms of contact coverage and also duration of protection. We must also know to what extent the reciprocity-based system is feasible in terms of implementation, both in the context of withdrawal agreement, but then also in the context of the future relationships. So yes, there are many outstanding issues, many things still to reflect and consider. And what is important, just let me to conclude with this, what is important that we see that the solutions found and the impact on the lives of citizens concerned will be for us also an important lessons for this future reflection with regard to the concept of EU citizenship and also the protection of individuals, and how this can be also reinforced. So the tasks are definitely very demanding, and the way we perform and deliver will surely have a historical significance. Thank you very much.
Thank you very much, Danuta. From the outset, Guy Verhofstadt indicated that citizens' rights would be in the first chapter of negotiations, and he has put this issue at the top of the agenda. So I'm delighted to introduce the European Parliament's chief Brexit negotiator. Guy, you have the floor.
Yep. Thank you very much, Chair. So I'm very happy to be here, and I want to thank the three committees to have joined forces to organize this public hearing about the rights of EU citizens in the UK and the rights of the UK citizens in the EU, because I want to speak about, in fact, not one, but in fact three different situations. First is the EU citizens in the UK. We will feel the consequences of the Brexit. Secondly, about the UK citizens in the EU. But also about the third category, UK citizens in the UK. We want to keep a link with the European Union. So I see not one, not two, but in fact three, I should say, categories of citizens, if you call it like that, European citizens or UK citizens who are in fact affected by Brexit. And if I use the word affected, is affected. If there are today victims of the Brexit decision, and I put victims between brackets, then it are citizens because of the uncertainty that has been created now more or less 1 year ago. This uncertainty, you feel it in every contact you have with all UK citizens on the continent or EU citizens in Britain, and even with UK citizens who, against their will, lost their EU or will lose their EU citizenship. In total, I have received individual mails and letters between 6,000 and 7,000 of individual people, UK citizens, an EU citizen, describing a personal situation. This is not a typical letter that turns around when something is happening and then everybody make a copy-paste of the same. No, individual letters. 1 page, 2 page, 5 page, describing one or other personal situation. Saying, at the end, in most of these letters, the conclusion is the same. I don't want to do. I don't know what to do. What is my status? What are my rights? Is it true what I'm hearing at the radio, at the television, in Britain or in Europe? So that doesn't make any difference. And at the same time, we received more, as Cecilia have indicated, more than 100 petitions in the Parliament here, and one of them, for example, is a petition about another issue, the link between UK citizens and the European Union. If it is possible to keep this link, we received more than 300,000 signatures. So what we are talking about is not a problem in a number of individual cases. No, it's huge, it's massive, but at the same time, it's not only massive, but it's individual. Every case is different, and people are anxious. People are afraid of what is happening. And I think that we are talking about 3 million EU citizens living in the UK. We talk about 1.2 million of UK citizens living in the EU. All an uncertainty for most of them linked to the decision that have been taken. Most of them, I can tell you, have moved in good faith, maybe years ago, and have made from their new country their home. And I think what our objective has to be, on both sides, for EU nationals as for UK nationals, is that they can continue their rights for the rest of their lives. So in the resolution of the Parliament, and we have influenced in that respect also the guidelines of the European Council, and I come back to a third element, to the negotiation directives that will be adopted in a few weeks by the General Affairs Council on the 22nd of May. We have secured that for all the three institutions and in all the position papers and mandates and guidelines and directives of all these institutions, the interest of the EU and UK citizens is paramount, is the key issue. And we have this made clear, as you know, since the beginning, reflected, as you know, in a resolution that has been tabled the very same day that the government triggered, the UK government triggered Article 50, and a resolution, as you know, that has been adopted on the 5th of April with a huge majority. And the extent to which this issue, the issue of the citizens' rights, will be dealt with satisfaction, I should say, as we expected, will be also a crucial, a key determining factor when the Parliament will be called to give his consent on the withdrawal agreement. I think that is already indicated in the resolution. We will never, that's indicated in the resolution, give a consent if the issue of the citizens' rights on both sides has not been dealt in a satisfactory, I should say, way. And the same is also in the European Council guidelines that has been adopted on the 29th of April by the 27 heads of states and government in a record time of, as we know, 4 minutes. That's a new record, apparently, in Council. And I can tell you, and I come back to this more in detail now, that also in the draft negotiation directive, which will be adopted on the 22nd of May by the General Affairs Council, the rights of citizens represent the first issue to be tackled in the negotiation. That's the position of all three European institutions. I can tell you that Parliament has been involved in the preparation of the guidelines. We are also involved in the preparation of the negotiation directives. And yesterday, in the name of the Conference of Presidents and the Brexit Steering Group, including the chairs of the different involved committees, I have sent a number of additional proposals to the General Affairs Council, so that I hope that these proposals can be taken on board on the 22nd of May when they decide on it. In top of that, and before going more into detail where we are for the moment, it will be possible also for the Parliament to do two things, I think, and it's absolutely necessary. First of all, to prepare our position more in detail on these citizens' rights with the three commissions. Not that I see the necessity now, tomorrow, to table immediately a resolution of the Parliament on this, but I think politically it's absolutely necessary that we prepare a resolution on citizens' rights with the three committees who are involved. And our proposal is to use this at the right moment. The moment where we need to put pressure on the Commission who is negotiating, on the Council who is scrutinizing, like we are scrutinizing, this negotiation process. Because I think that that is the main role we can play, to repeat in a resolution what is already in the guidelines, or what is already in our resolution, or what is already will be taken on board in the negotiation directives of the General Affairs Council, that has no added value. What Parliament needs to do, I think, is be ready with content, with a resolution, at a moment where it is politically needed, when we see that there are a hesitation, for example, by the EU side or by the UK side to go further or to conclude on the issue of the citizens' rights. And then it can be absolutely key and necessary that we come out. And I think that together with the three committees and with the Conference of Presidents, we have to prepare ourselves for that. And secondly, we can then decide together that's the moment to increase pressure, to put the necessary pressure on the negotiation to succeed in an agreement on these citizens' rights. In my opinion, what we have to do is, in any way, to start the negotiation after the 8th of June with citizens' rights. To try to be ready the fastest as possible in the months after that. It can take weeks, it can take months, I don't know. But in any way, it has to be the first point on the agenda of the negotiation. And secondly, I think it's also possible to conclude on citizens' rights and to make it public so that we take away the uncertainty that exists today, even when I know very well that formally the chapter on citizens' rights is a chapter in the withdrawal agreement based on Article 50 of the treaty. But nothing makes it impossible in the treaty or in the way we deal with the rights of citizens to start with it, to conclude on it, to make it public, what is the outcome of it, and then to formalize it naturally in the normal way as the first chapter of the withdrawal agreement that will be taken. And that is in fact, I hope, on where we can start and on which we can agree to start with it, in the weeks after the 8th of June and the months after the 8th of June to conclude on it, but not only to conclude on it, also to make the result public immediately so that we can take away the uncertainty that has been created now the last months on these rights of the citizens and then later on, but that's more the formal side of the job, it will be taken on board in the withdrawal agreement. So, secondly, other role for the Parliament and for the committees is that it is our intention that we make also an assessment not only on the citizens' rights and on other issues that are not on the agenda today, but it is also necessary that the Parliament take its responsibility to decide if yes or no there is sufficient progress to go from phase one of the negotiation to phase 2 of the negotiation. As you know, in the guidelines of the European Council, the negotiations has been divided in 2 phases. The first phase is the withdrawal agreement, starting with the citizens' rights. And what the guidelines are saying, and we have supported it very clearly with the Parliament, is that we can only go in phase 2, that means a debate and a discussion and a negotiation on the future relationship between the UK and the EU, if there is sufficient progress in the first phase. I think it's absolutely key that before the European Council is making its assessment about sufficient progress is made, that Parliament is doing that assessment before the Council. And that we take naturally as a key element for such an assessment the citizens' rights on board. has to be the first element. Has that problem been tackled? Has an agreement been found? That seems to me the first element of that assessment if, as Parliament, we give our assessment on the issue of the sufficient progress to go into phase 2 of the negotiation. Let me now, if you allow me, Mr. Moraes, give maybe some insight in the negotiation directives that will be decided on the General Affairs Council of the 22nd of May. Why is it so important? Because the guidelines, that's, I should say, the general stuff, what the negotiations directives are doing is giving in detail what the European Union will put on the table of the negotiation. And as I already indicated, the committees and the political groups have already looked at the draft negotiation directives. We have also already reacted yesterday very concretely with a letter to the General Affairs Council. And what these negotiation directives are doing is, first of all, to tell who we want to protect. The negotiation directives are indicating, and we are fully in line with it, that not only the economically active people, but also inactive persons who are living or working today in the United Kingdom needs to be protected. First element. The negotiation directives also indicate that we want to protect those who have lived or worked there also in the past. So not only the people living there today, also those who have lived in the past there. 3, we have indicated, or we indicate as European Union, that those who will be living or working there before the date of exit of the United Kingdom needs to be protected. So for us, the date, the cut-off date, like we call it, is the date of exit, the date of the withdrawal, and no other date, because there have been some rumours that from the UK side it should be the date of the triggering, but it's obvious that this cannot be accepted. It's the date of the withdrawal. And last element, all the family members of these different categories. That are the people to be protected. And then the second element, what the negotiation directives are doing, is indicating what the rights are that have to be protected, and they are not limited naturally to only the right of residence, but also, and I give an enumeration of it, access to healthcare, access to education, access to the labour market, and then very important also as a complement of it, the recognition of diplomas, recognition of certificates, and the recognition of qualification. I will not bore you because otherwise I can continue the whole afternoon, but that's not, I think, the goal of today. The possible situations and combinations to consider are enormous. I think that already Mr. Barnier, a few days ago, in a speech that he has given to European University Institute in Florence on the State of the Union, has given a number of examples illustrating the practical cases. And it was a long list, and I will not cover them all. But it's also clear that beyond who is protected and what rights are protected is also the way they are protected that is important. That means the legal protection and enforcement, also that has to be addressed. And in our opinion, as Parliament, it can only be based on 2 issues, the EU law on the one hand, and the oversight of the European Court of Justice at the other hand. And then finally, also as for the EU economic area, in our point of view, the UK would be bound by past case law, take into account future law in the interpretation of these rights for citizens that continue to abide in the UK. So it's not a moment that is not moving. And again, I repeat, not to create a new judicial body, of course, as in our opinion the European Court of Justice law applies. And then a last element that I want to mention, UK citizens. living in the UK. So obviously, what we seek naturally is a reciprocal treatment in general for UK citizens. The rights of British citizens who live or lived, work or worked in one of the 27 countries of the European Union have, in all points of view, will be simultaneously taken into account. So we have sent it in that respect, as you know, Mr. Moraes, an amendment to the General Affairs Council to put the reciprocity as a key principle in these negotiation directives, what was until now not the case. That's a request of the Parliament. But I want to add one additional element. There is also the situation of those UK citizens who are living in the UK, who until now have EU citizenship and don't want, as they express it individually, to lose the rights associated with that EU citizenship. And that's not an easy issue, because legally speaking, the protection of the rights they currently have sounds impossible. There is a possibility always to do it, change the treaties, but I don't, that appetite is not so big on this issue. But what we could do is we cannot naturally create a special citizenship for UK citizens for the simple reason that EU citizens are nationals of EU member states. EU citizenship is in fact depending on the citizenship of an EU member state. It's in fact, it complements the national citizenship by providing rights to nationals of EU member states. But what we could do, and that is what is in Article 27, if I don't make a mistake, I'm looking to Mr. Colbert to verify it in the resolution of the European Parliament, what we could do is to envisage and to offer, as part of the future agreement, the possibility for UK citizens who have lost their citizenship right outside their will to offer a certain advantages, privileges, treatment. You call it what you will. And that could include a number of issues. Right of residence, for example. The possibility to initiate the European Citizens Initiative, which in my opinion in the treaty is not limited to European Union citizens. Or petition. Or the question of consular protection, or the issue or the possibility to let them participate in EP elections, European elections. Certainly, if a big dream, not my personal dream, but also a personal dream of mine, of transnational list could be realized in the coming months and the coming years. So I think that what we haven't done now, until now, Mr. Moraes, is that based on paragraph 27 of Parliament's Brexit resolution, which stipulates that we want to examine that possibility, we have asked, based on a conceptual paper, to Council and to Mrs. Jourova, the Commissioner of the European Commission, to start to examine that and to give us an answer on this possibility. Can it be done? How it will be done? How far it can be done? What should be part of that offer that we, as European Union, are doing to the individual citizens, UK citizens in the UK who want to keep a link with Europe? So also that element is in our idea part of the whole of the whole chapter that is the first chapter that we have to discuss with the UK authorities. So I'm sorry that I have maybe taken too much time that was allowed me, but I thought, based on where we are in the negotiation process, in the preparing of the negotiation process, in the conclusion on the negotiation directives, that is the right moment to abuse a little bit the time that I never have in the plenary. Thank you.
Thank you very much. And I would now like to warmly welcome our guest speakers and some of the petitioners. Then, hopefully, after your interventions, if time allows, that is, we will also have some time for questions and answers. But first, we have the opportunity to listening to Anne-Laure Donsky, who is a founding member of the 3 Million, which is a grassroots organization for EU citizens living in the UK. Now, Ms. Donsky, the floor is yours.
Ladies and gentlemen, members of the European Parliament and the European Commission, I would like to thank you on behalf of the 3 million to allow us to present the case of over 3 million citizens living in the UK. The outcome of the referendum and the anxiety faced by the majority of us has been well documented. Since the referendum, there have been countless reports of EU citizens facing difficulties in their daily lives. For instance, opening bank accounts, potential tenants being turned down, people being discouraged or turned down for jobs, as well as being confronted to job adverts which openly discriminate on the basis of nationality, etc. This may be anecdotal evidence, but it is happening. And it is happening because of a lack of clarity and guarantee about our existing rights and their continuation from April 2019. There is a consensus that the current process of registering EU citizens is simply not fit for purpose. Problems stem from the fact that the UK, unlike many EU countries, has historically chosen not to register EU nationals. This has resulted in the current situation, with the system creaking at the seams, with hundreds of thousands of people applying and the Home Office trying to put people off from doing so by issuing vague reassurances that nothing has changed, encouraging them instead to register for email alerts. The 3 Million has recently conducted a large-scale survey of nearly 2,800 respondents, providing evidence that the system is not working, is overcomplicated and unfair. Scoping, also done by the 3 Million at the request of the UK government, also shows that the UK is totally unique in its unreasonable requests and complexity of process and for permanent residency. This makes it a very, very tall order for EU citizens to claim their rights. Recent media reports that Mrs May allegedly hinted that EU citizens could become third country nationals pretty much overnight through a simple change of status have brought fresh concerns. Whether this is even possible or desirable raises new questions about how we will be treated. I cannot stress enough that what is at stake is certainty about our lives, about our families, certainty about our rights, right to work, to have access to health services and education, to build a business, etc. In other words, certainty about those indivisible rights, which derive from the right of residency, as described in the report of the UK House of Lords EU Committee on Brexit Acquired Rights. These rights are very much at risk and must be guaranteed and preserved not just for the short or medium term, but permanently, and they must be dealt with as early as possible at the start of the Brexit negotiations. So our concerns are that EU citizens currently living in the UK and whose status is uncertain, either because they never felt the need to apply for permanent residency, because it was never required of them under freedom of movement, or because they do not qualify due to the way the UK interprets and implements aspects of EU legislation, will most certainly see their status worsen. That a failure of the Brexit negotiations could lead us to being subjected to UK immigration legislation as for non-EEA citizens. This would most likely exclude huge numbers, if not most of us, in terms of qualifying criteria and due to the associated exorbitant costs. What do we want? First, concerning existing and indivisible rights of EU citizens currently living in the UK. We strongly welcome the European Council's guidelines for the negotiations, but it is important to note that we fundamentally disagree with the principle that nothing is agreed until everything is agreed. When it comes to an agreement on citizens' rights, this will cause very real difficulties for people trying to get jobs, etc. In other words, trying to lead a normal life, potentially for another 2 years or more. So given the exceptional nature of the circumstances in which up to 5 million people find themselves, and that's including our friends, British citizens living in the EU, we call on all negotiating parties to support an early ring-fenced, legally binding, separate agreement preserving our indivisible rights as part of the negotiations under Article 50. We call on the European Parliament to support this by means of a separate resolution on citizens' rights, setting key principles and guidelines underpinning an agreement to preserve citizens' rights. A separate agreement fits the moral argument that people's lives matter above and beyond anything else, and should be dealt with away from the rest of the Brexit negotiations. We therefore ask the Council to amend the negotiation directives to allow for this to happen, especially since there may be room for flexibility. In short, we are not bargaining chips, nor are we commodities to be negotiated. When we met with Monsieur Barnier at the end of March, we came away with the notion that an agreement in principle on the guaranteeing of all existing rights could be achieved. When we met with Mr. Tajani 3 weeks ago in London, he was also hopeful of the European Parliament adopting a separate resolution on citizens' rights that would pave the way for such an agreement. 2. Concerning the process of claiming our rights. The complexity of the process, its Kafkaesque nature, the inconsistent quality of the assessment of the required documentation by overworked Home Office staff, the high rejection rate, etc., have all contributed to a high level of anxiety and even sheer despair amongst many, and certainly amongst the 30,000+ members of our online discussion forum. Permanent residency is also a required step to acquire British citizenship. We therefore ask for a new, simplified or bespoke registration process that would allow us to claim our rights, but it must be fair, swift, simple and free. 3. Urgently resolving the main hurdles to claiming our rights. Comprehensive sickness insurance. The UK government's failure to recognise access to the NHS as sufficient to fulfil the requirements for comprehensive sickness insurance is particularly discriminatory for thousands of EU nationals amongst the most vulnerable population groups. These include individuals who, during their period of residence in the UK, were at any time students, self-sufficient persons, including carers, stay-at-home parents, and retirees. This little-known requirement means that often many have unknowingly broken the 5-year residency rule. The 3 million has collected a lot of evidence and built case studies that illustrate the existence of this discrimination. Minimum income threshold. The UK's interpretation of what constitutes genuine and effective employment for workers, that's employees, self-employed people, is discriminatory against part-time workers on minimum wage and all those not earning enough to cross the threshold set by the UK government. For instance, people on 0-hour contracts, people who only work on an irregular basis due to health conditions, disabilities or caring duties. The imposition of an earnings threshold is in contradiction with Article 7(1)(a) of the Citizens Directive, which does not require or set a minimum income for workers to exercise their treaty rights. And this is another little-known requirement from 2014, so fairly recent, which few are aware of. People with disabilities or long-term health conditions are not covered under 2004 EU directives. No one chooses to become ill or to have a disability. And yet, these people are not in a position to exercise their treaty rights and are therefore at risk. EU citizens in the process of acquiring their rights. EU citizens who will have been residents in the UK for less than 5 years by the time the UK exits the EU will not be able to apply for permanent residence as they will not have had enough time to exercise their treaty rights. Long absences from the UK, people who already have PR status, lose their residence rights if they leave the UK for more than 2 years. And they include people who were born in the UK, have been long-term residents in the UK, but need to travel for career purposes or to look after family members. And then there's a direct appeal to Mr. Verhofstadt. Loss of access to benefits associated with living in an EU member state. Once the UK has left the EU, EU citizens living in the UK risk being treated as non-EU citizens by member states when it comes to accessing benefits conferred under EU freedom of movement laws and which cover a wide range of issues. For instance, at the moment, an EU citizen living in the UK who wishes to do a long-distance degree in an EU country will be paying that country's fees. Post-Brexit, the same student may be considered as a non-EU student and required to pay non-EU fees, which are much, much higher. Another example concerns voting rights in local elections, which we stand to lose. So these hurdles are, of course, only the tip of the iceberg. Crucially, what they point to is the question of what happens to people who are currently not deemed to be lawful residents because they are not or have not been able to exercise their treaty rights under the current registration process. At 30%, the rejection rate is very high, and while people are no longer told to make preparations to leave the UK, their situation remains precarious and their anxiety immense. The categories of people affected, as well as the life scenarios involved, are numerous and complex. We do acknowledge that the EU cannot renounce its own statute, which requires 5 years of lawful residence, but we would argue that there is room for manoeuvre in how the criteria are interpreted so that everyone who is currently living in the UK can gain permanent residency, not just those deemed lawful before Brexit. So the issue is threefold. 1, identifying and registering EU citizens living in the UK. 2, granting permanent residency to everyone, including those who do not currently qualify for PR and who should be allowed to accrue rights. And 3, as well as the preservation and guarantee of indivisible rights permanently. 4th point, involving EU and UK citizens' organisations. The 3 million has been working very closely with our colleagues at British in Europe, the largest coalition of British citizens living in Europe, who have many issues and interests in common. We feel very strongly that all organisations representing the views and interests of 5 million EU citizens must be recognised, supported and fully involved at all stages of the negotiations concerning the preservation of their existing rights and the implementation of guarantees and safeguards for the future. And I would just like to finish by saying that the European Parliament and the Commission have been very supportive of our plight to date, and we are very thankful as well to all the many MEPs who have taken our concerns to heart. And I thank you for your attention.
Thank you very much, and thank you for your work sometimes under difficult circumstances. And again, an activist, sometimes typical of the work that has been done in this area, is Mr. Jan Dorfel, who's a British barrister with over a decade's experience in nationality and related law. Mr. Dorfel, you have the floor.
Thank you very much, ladies and gentlemen, members of the European Parliament, Mr. Chairman Moraes. I would like to thank you very much, especially the LIBE Committee, Employment and Petitions Committee, for giving me the honour to speak today. Being half German and half British, and speaking every language now with an accent, for me, Europe is not a theoretical idea or the enemy, as Theresa May sees it, but it's home. And my mother and stepfather, my mother being British, my father and stepfather German, have travelled here from Frankfurt today. That is what Europe means to me. So I'm going to address some aspects of the situation and rights of EU citizens in the UK. What you see on the slide now, most of that has been raised by Anne Law just now, and I'm going to deal with the dilemma faced in relation to applying for British citizenship and what will happen to family members wishing to join now or in the future. And I think a lot of what I'm going to say will deal with, or will also address, the vital point made by Mr. Verhofstadt about why the European Court of Justice continued jurisdiction is necessary, because the UK fails at present to apply EU law, and I will show some ideas of that now, which gives an indication of how they're going to try to restrict the class of persons they would give European rights to, especially family members. If you wouldn't mind bringing the slide up in its entirety, thank you very much. I'm not going to reiterate that, just the need being, of course, that the rights continue in the future, are guaranteed and enforced by the CJEU. If you wouldn't mind going on to the next slide. Some references have been made already by UNLAW. Some that have been publicized is the onerous forms, which have now been made mandatory. So it's for permanent residents, a paper form, it's an 85-page paper form. It's less online. But nonetheless, it requires citizens to list all absences from the UK since they arrived. So that means 25 years sometimes worth of absences. It's impossible to do. In addition, the Home Office has a very restrictive approach, which stems from the intention to keep people out as opposed to enabling free movement. So the restrictive approach being one case that had been highlighted by The Guardian of Monique Hawkins, who wasn't able to put her passport in at the time because she had to keep travelling and exercising her right to free movement, and her application was returned, and later through media attention she got permanent residence and nationality. Other issues are that the Home Office doesn't assess whether, for example, children born in the UK to EU nationals might actually already be British citizens. Instead, there was a case highlighted of a refusal of a permanent residence card. So there's this thinking in the box and a tick box exercise at best, but not actually considering whether people do already or have already acquired certain rights. Another point is that additional information isn't requested, the application is instead refused. So people then have to either appeal again or apply again or appeal, and current waiting times are 33 weeks for EU appeals. It's now way over a year for non-EU cases. And, which came as a surprise to a lot of lawyers, actually including the Home Office, the courts in the UK have held, the upper tribunal has held, that there is no appeal right anymore for other family members, known in Britain as extended family members. I will come to what they comprise, but it's a group of family members that isn't directly protected by the Free Movement Directive, but strongly referred to therein. So if I could have the next slide, please. The problem I want to focus on is that EU nationals who acquire British citizenship lose their EU rights despite an exercise of their treaty rights. And I will come to that on the next slide. Then UK nationals who have exercised treaty rights abroad, so-called Surinder Singh cases, are not given the full EU rights. And if you could please go to the next slide. Thank you very much. I think there's a slide before. Thank you. Exactly. So prior to 2012, the UK treated dual nationals as EU nationals. Then there was a case called McCarthy, which was indeed on the facts a very unfortunate case of a British national who also had Irish nationality but had never exercised treaty rights. So the European Court of Justice rightly held that she couldn't benefit from EU rights. So what did the UK do with that finding? It said dual nationals will no longer have any EU rights. So the definition in the Immigration EEA regulations 2016, but in force since 2012, means that an EEA national is a national of an EEA state who is not also a British citizen. So now you have the panic of people applying for permanent residence cards and then for dual nationality, without realizing that the elderly mother who might be living in Colombia will no longer be able to come because they don't have the EU rights of a dependent relative in the ascending line being able to join. They're covered by draconian immigration rules. I will come to that in the next slide. So there's the resulting loss of existing residence rights also by family members. And that's the issue raised about not tearing families apart. Now, let's say you're a French national with a Colombian husband. You become British, giving up your French nationality. Your Colombian husband becomes illegal at that point, actually. You will then have to apply under the immigration rules, or he will have to apply for status. And at that point, you need to earn £18,600. a condition that was upheld by the UK Supreme Court just recently. If you could have the next slide, please. Now, I'm looking at juxtaposing the immigration rules provisions on adult dependent relatives with the Equal Treatment Directive 2004/38. Now, under EU law, as you know, your children can join if they're aged under 21. No conditions attached to that apart from the age. And other dependents of yourself or your spouse can join if they're dependent in the ascending line, or children that are dependent but over 21.
Yeah, and I'm just going to mention this will be available online
Yes.
immediately after the meeting. Don't panic, relax. Don't take too many notes. It will be available immediately.
Excellent. Whereas the immigration rules are draconian. If you're over 18, whether child or parent, brothers, sisters, you need to have long-term personal care needs to perform everyday tasks. And care mustn't be available in that country of origin because it isn't available or affordable. But at the same time, as a British national, you have to be able to guarantee that you can pay all the medical bills in the UK. So we're looking at countries that have no health system, or at countries where health systems are more expensive, maybe the US. This has virtually led to a shutdown of bringing in relatives. And a challenge is going through the courts at the moment, the Brexit challenge, but I have no doubt that on Article 8, right to family life, that might well be refused. So it goes entirely against the Free Movement Directive or Equal Treatment Directive that states should facilitate entry and residence of other family members which are set out below, which means someone who's dependent or has been a member of your household, including durable partners. The next slide, please. The other area of cases where the UK is clamping down very hard are the Surinder Singh cases. And I guess that's part of the category, actually, of EU nationals in the UK, because these are British citizens, or they're certainly part of the third category, by Mr. Verhofstadt, of UK nationals wanting to retain links, but in fact they have already acquired EU rights as a matter of law. These are UK citizens that have gone abroad to France, worked there, now come back to the UK, and 25 years ago the European Court of Justice told the UK government, these people aren't governed by national law, these people are governed by EU law. And in fact, the government had said, oh, but then they're treated better, and the European Court of Justice said, you're welcome to treat your nationals better. But since then, the test hasn't sunk in because the denial means that even now in the Immigration EEA Regulations 2016, and that's on the next slide, the government has tightened up further because they have said they have put a different provision in for UK nationals who are British, who are EU nationals, effectively, instead of treating them like everybody else. So the UK national who's worked abroad is not being treated like the French national who's just moved to England to work there. And they are requiring, for example, that a British citizen is or was exercising treaty rights in an EEA state immediately before returning to the UK. So that indicates to me that this is a suggestion that EU rights can be lost. So if you return, if you've done other things in between, you come to the UK after, they will tell you, no, you're now being treated as a purely British citizen. They also require residence together in the EEA state. That is not a requirement in the directive. And they say the residence has to be genuine. So what they're doing, in the light of the adult dependent relative rule that we just saw, which keeps out family members, British nationals have said, well, then I'm going to Ireland, the Republic of Ireland. I'm going to work there for 3 months. I'm going to come back and I'm an EU national. And then the UK government says, no, because we can't have you do this because we say you're not EU nationals then. You shouldn't be treated as one. And have included the genuineness test and has said that includes whether your centre of life transferred to the other country. So let's say I have cases where a young child, where the family, part of the family is then in Ireland, part of the family is in the UK because there's education ongoing, etc. And the government has said, oh no, the whole family hasn't moved their centre of life, meaning you're now obliged to exercise treaty rights as opposed to it being just a freedom. And then it says that, if you could put the next slide on, that if you actually moved in order as a means for circumventing any immigration laws applying to non-EEA nationals to which the family member would otherwise be subject, well, then that doesn't apply to you. You can't benefit. So the UK is undermining EU law by saying the motive counts, which the European Court of Justice held in Anchorage. The motive doesn't count. It matters whether you have exercised treaty rights as a matter of fact or not. So that's what the government is doing. So I think in negotiations, it's very likely that the government is going to run this, saying British nationals who've exercised treaty rights don't count, they're just British nationals. And the point made in the next two slides, which are then available online, is that references have been made to the European Court of Justice, challenging both the Surinder Singh application and the question whether there are, in fact, whether you lose your EU rights when you acquire British citizenship. And that's another reason why the European Court of Justice should contain and why it's a moving body of law in the definition of treaty rights, because no doubt the UK government will come up with future restrictions on those rights. Thank you very much, and I'm sorry for overrunning.
Thank you very much. The next speaker is Mr. Charlie Jeffrey, who is a professor at the University of Edinburgh, and I'm happy to extend the floor to you.
Thank you very much indeed. Many thanks for the opportunity to speak to this hearing this afternoon. I was asked to talk about Erasmus+, the student mobility programme that the European Union has funded, which is celebrating its 30th anniversary this year. I'll talk to some extent about the University of Edinburgh's experience with that programme, but also make general comments. And I wanted to start by pointing out an irony. We are now considering the possibility of the UK's departure from the Erasmus programme, just as we're celebrating that 30th anniversary of something which was set up by a Brit, by one of the pioneering UK civil servants in Brussels, Howell Kerry-Jones, who was one of the cohort of British entrants to the European Commission back in 1973, and was the then EEC's first Director of Education and Training, introducing a pilot programme for what became Erasmus in 1976, with the full programme following just a decade later. So I wanted to pay tribute, as I begin, to Howell Kerry-Jones's vision, tenacity and impact. Because what Howell Kerry-Jones recognised was that we, universities and the societies around us, drive on the discovery, the absorption, the dissemination of knowledge more quickly and more effectively through the movement and interaction of people and ideas from different places. Now, a very strong view at the University of Edinburgh, and I think it's a view held across UK universities and indeed across universities in the EU and beyond, is that a programme like Erasmus+, which fosters that movement and that interaction, is an asset not just for universities and students, but it's a common good. It's something which benefits our societies as a whole. And putting that at risk, as the Brexit referendum has done, is in our same strong view, therefore a problem not just for universities and students, but for our societies as a whole. Unfortunately, and I'll come back to this later, that is a widely shared view. Firstly, though, what's the scale of the issue? Some facts and figures. By 2020, across the EU as a whole, some 5.5 million students will have benefited from Erasmus exchange. Huge amount. We have an annual rate in the UK of around 16,000 students heading outward to others in exchange agreements and 27,000 coming in. You'll see a distinction between the incoming and the outgoing. The incoming group is bigger. We should also remember that Erasmus fosters staff mobility. Professors move around, collaborating with partners elsewhere. And that provides a really substantial underpinning for other kinds of academic engagement. Turning to the University of Edinburgh, over the last 30 years or so, 12,000 of our students have benefited from Erasmus, and rather more than that, have benefited by coming to the University of Edinburgh with support from Erasmus. We are the #1 university in the UK for receiving students. We're #6 for sending them. We have over 250 Erasmus exchange agreements. And we've had very recently the welcome extension of Erasmus to exchanges beyond the EU via the International Credit Mobility Initiative. We have a further 99 exchanges supported by that mechanism. We have secured about 20% of the total funding for that mechanism in the UK. All of that together means quite obviously, quite transparently, that Erasmus is our most important international exchange and mobility programme. And pretty much every university in the EU would say the same thing. What benefits do we get from this? Universities UK, the collective body of universities in the UK, did an Erasmus impact survey last year, which showed that students who benefited from Erasmus exchanges have better academic outcomes. They do better in their degrees. They do better in their careers. Fewer are unemployed. Erasmus graduates tend to have higher salaries. We looked at this rather more closely in the University of Edinburgh last year by surveying our latest cohort. 71% of them, this is about 450 people, said that they gained knowledge and skills while on Erasmus exchange that they could not have gained simply by studying at the University of Edinburgh. 89% felt that they had won a better appreciation of other cultures. 90% believed that their employment prospects had been enhanced. 88% now want to work in an international context. All very substantial figures. Now, if you scale that up to the 5.5 million students who benefited from Erasmus over the last 30-odd years, then that is an enormous benefit for our societies. And just as a little aside, though I'm not entirely sure how this is calculated, there is an estimate that Erasmus has produced around about 1 million babies. Let me put some of that into the words of our students. I've got 4 testimonies here. Number 1, it was a fantastic year, and I would encourage anyone to do the same. The grant was very beneficial and really makes the opportunity accessible to all. And I stress, accessible to all. Erasmus gives additional funding for students from disadvantaged backgrounds who may not have the ability to call on family or other resources to help with the additional costs of studying or working abroad. Number 2, going abroad with Erasmus was the best thing I've ever done. It gave me the opportunity to live independently, fall in love with a new country, travel all around Europe and beyond, meet best friends from all over the world, and further my education tremendously, furthering education tremendously. Number 3, it has certainly improved my employability as I have proven experience of living abroad. The fact that I can now speak good French, Spanish and Italian is a huge draw for employers, as British people generally have shocking foreign language skills. Indeed, it's true. And the last one, a very heartfelt one, please don't let Brexit ruin this amazing opportunity for future young people in the UK. Indeed. So what next? How do we find a way of maintaining as much of those benefits as we possibly can? The ambition for us, clearly, I think that's the University of Edinburgh, every university in the UK, is to maintain full participation in Erasmus as a key item in the Brexit negotiations. And I want to quote the Prime Minister on this from her big speech setting out her 12 points to shape the Brexit negotiation. She said in that speech, I want us to be a magnet for international talent. Yep, very good. Students, that's international talent. She said there may be some specific European programmes in which we might want to participate. If so, it is reasonable that we should make an appropriate contribution. Okay. And she said also, so we will welcome agreement to continue to collaborate with our European partners on major science, technology and research initiatives. So talent, participation, paying for participation in programmes, focusing on science and research. I think most of that is actually focused on EU research funding programmes and not on Erasmus. Our ambition as universities in the UK is to get Erasmus up to that same level of priority for the UK government. Now, some might say, well, that's simply cherry picking, picking the good bits and trying to keep those while not accepting the full implications of membership. I don't think that's true. Cherry picking is something which signifies advantage on one side only. I think Erasmus participation is something which is recognised as of mutual benefit across the EU, whether or not the UK is a full member of the EU or not. I think universities across Europe would support the UK remaining a full participant in some way in the Erasmus scheme. I think that's partly because we all recognise that the movement of people and ideas is a good thing which drives on what we do in our universities. But there's also an English language element to it, and I have to contest the view of the European Commission President, as expressed recently, about the English language. I don't think it is going to go away in any sense. I think there will be huge demand across the EU to come to the UK to study in the English language. That is something which is of mutual benefit. So not cherry picking. Now, we might not get that. We don't know quite how these negotiations will work out. So if we didn't, what would be the alternatives? Well, Switzerland has given us a model, a Swiss-style parallel system which could be applied as a national system across the UK, perhaps even a system in Scotland which has its own distinctiveness. And you might be interested to know that Scotland today saw the launch by university rectors, by university staff, trade unions and by university students, a manifesto for the mobility of talent. This is something which is really strongly recognised in Scotland. So we could do something like that. But it wouldn't be as good. We would lose the brand. Erasmus has a very, very powerful brand. And it would have to be funded. And we can foresee, I think, that there will be other calls on the UK budget post-Brexit. Farmers and others will be saying, well, we need extra support now we've lost what the European Union gave us. So I don't think we could ever envisage something like that having impact on the same scale. Final thing, if we didn't manage that, would simply be a free-for-all, with each university acting individually to support international mobility. And we at the University of Edinburgh might have already made a start on that, because we have given a guarantee to students thinking of joining the university in 2018 on courses which have a compulsory year abroad, for which Erasmus has been the exchange programme. We have said that we will cover the costs if we are no longer able to participate in Erasmus. Now, if everybody were to do that, we would have a very unsatisfactory situation. I think the amount of exchange would be much smaller, it would be very variable across universities, and there would be unequal opportunities for students, and I suspect in particular students from less privileged backgrounds would be the ones who in particular would lose opportunities. So these alternatives are not great alternatives, and that's why it's a very, very clear view across universities in the UK that full participation in Erasmus has to be a key priority. Thank you.
Our next speaker is Ms. Julia Onslow-Cole. She is a partner, legal markets leader, and head of global immigration in PricewaterhouseCoopers in London. In fact, she is a key expert on the Brexit task force of the PricewaterhouseCoopers, but she also sits on the Mayor of London Brexit Experts Advisory Group. The floor is yours, Ms.
Thank you. Thank you. Yes. And as you've just said, I head the global immigration practice at PwC, and as well as the fact I'm the legal markets leader, and sit on Sadiq Khan, the Mayor of London's Brexit Expert Advisory Group. And I'm very grateful indeed for the opportunity of sharing my experiences with you today, as it's essential that European parliamentarians are part of the ongoing dialogue and debate, which is of vital importance for business, and I'm really delighted to be here today. Thank you. So I lead the largest global immigration network with more than 1,600 experts in 171 countries. And in March this year, I was appointed to the global leadership team for PwC's worldwide legal practice, covering all lines of service. And my role allows me to have a deep understanding of the challenges that business face in relation to Brexit. And since the referendum, I've been speaking to business across a wide range of sectors, from startups to large multinationals, to understand the challenges they face. And through my extensive cross-sector conversations with business, I've pulled together some themes to share with you, which are reflective of the conversations that I've had with business to date. So businesses have really tried to identify their existing EU employees and also analyse the impact on their future growth plans of significant changes to the immigration system. And many businesses have struggled to identify their existing EU workforce, as they were not required to retain this information previously. And this has resulted in wide-scale data-gathering exercises to understand the issues at hand in order to carry on with business as usual. Prior to the triggering of Article 50, a large proportion of UK businesses were already supporting their EU employees in the UK, providing them with key information about their existing rights through webinars and workshops so that they can understand what action, if any, can be taken. And we've been offering our clients a wide range of support. And even though it's not necessary for EU citizens to register the fact that they're exercising EU rights in the UK, there have been a significant number of registration applications, including permanent residents. And some employers are supporting employees with these applications, and businesses that have assisted their workforce by either providing information or supporting their employees' applications have reported that they've had high levels of employee engagement as well as a result. The feedback that we've received from our clients has been overwhelmingly positive, as their EU populations have felt valued and informed through this uncertain period. Earlier this year, we released a joint report with London First entitled Facing Facts: The Impact of Migrants on London, its Workforce and its Economy. and I will be very pleased to circulate this to committee members, and I have a few hard copies of the report with me if you'd like one. The aim of the report is to provide the UK government with a fact base to assist them with future negotiations, and the report is unique as PwC were granted access to the Office of National Statistics virtual micro-laboratory to review detailed, granular data on the UK's workforce with an emphasis on London. And the report looked at the growth of London's workforce over a 10-year period from 2005 to 2015. And the report concluded that, on average, each migrant worker contributes a net additional £46,000 sterling in gross value add per annum to London's economy. And with approximately 1.8 million migrant workers, that amounts to 83 billion, almost 1/4 of London's GVA per annum. And the report analyses the impact of migrants on different sectors of the economy in London, and it drills down into 5 sectors that impact the economy. And today I will speak about construction, finance and the NHS. So there are some 300,000 construction workers in London, half of whom are migrants. And of the half who are UK born, around 1/5 are expected to retire in the next 5 years. And at the same time, the construction sector is growing strongly, with numerous infrastructure projects and new housing projects underway. Vacancies are rising and apprenticeships are not being completed. And this conundrum caused one construction industry executive to tell me that there could be a skills shortage of 230,000 people in 5 years' time. The finance sector accounts for just over 1/6 of London's economy. The industry employs approximately 1.1 million people across the UK, with 293,900 in London. And 15% of the total workforce is EU-born. As you can imagine, my clients in the finance industry are very concerned about the long-term future of their EU population, especially those who hold senior roles, as they're constantly headhunted by other organisations, not only in the UK but around the world. The NHS employs 1.2 million workers in England, with 175,000 people in London. And across the UK, approximately 12% of all NHS roles are filled by migrant workers, and in London specifically, this number increases to 25%. EU doctors make up 13% of the total numbers of doctors in London, and it shows that the EU population is key to the NHS. A further interesting statistic is that 69% of all NHS trusts and health boards are actively recruiting staff from abroad. In summary, our report highlights the hugely positive impact that all migrants have had on economic growth. And I'm pleased that both the UK and EU27 have said that the rights of EU nationals in the UK and UK nationals in the EU are a priority for the talks. Businesses I have spoken to agree. And early clarity on this would be a positive message both to the individuals concerned and to businesses. Business also welcomes the idea of a phased implementation period so that there are no sudden changes to future immigration policy, and they've also reiterated that they will need ample time to prepare for a post-Brexit immigration landscape. From the perspective of EU citizens living in the UK, my view is that they will expect the UK government to set out clearly both their rights and establish a mechanism for redress. Continued dialogue is key, and forums like this are essential to the ongoing debate. I agree with Michel Barnier that to reach a reciprocal agreement will be both easy and complex at the same time, but I'm sure that a sensible agreement will be reached.
Thank you, and we will conclude this panel with Mr. Jonathan Portes, who is a professor of economics and public policy in the Department of Political Economy at King's College in London. The floor is yours.
Good afternoon, and thank you for inviting me. A lot of what I would have covered has, of course, been covered by previous speakers, particularly on some of the details, and I would associate myself with the comments, and particularly the description of the current legal position by Mr. Durfel and some of the broader psychological and political issues for citizens affected by Muzdonsky, as well as the economic arguments advanced by my colleague Julia to my left. All of these have a lot of force. So I think what I will try and do is try and set out at perhaps a higher and more general level, from a public policy point of view, what a way forward might look like. And I am addressing these remarks, I hope, not just to you, members of the European Parliament, but also very much to the Commission, to the governments of the the EU 27 member states, and of course, perhaps most of all, to the UK government. I think it is about time that all parties here got their act together, to be quite frank, and began to take some effort to resolve the situation. So if we could move on, that I think has been covered, so if we could skip that, and I will leave those for people who wish to read more about the data and statistics in this slide and the next slide, and proceed to the next one, which sets out the current position. So let me first say that the mess we're in now was both predictable and frequently predicted. I and others pointed out during the campaign that the assurances from the Vote Leave campaign that EU citizens in the UK and Britons living elsewhere had nothing to worry about were either ignorant, deceptive, or both. And so, sadly, it is proved. Unfortunately, since then, and I noted then the reasons for that, both the administrative difficulties associated with verifying rights to residence, which Muzdonsky correctly identified, but also the legal complexities, particularly the complexities around family rights, which Mr. Durfel highlighted, in particular the rights to be joined by spouses and some family members. But unfortunately, since then, not only have the UK and the EU 27 done little or nothing to resolve these issues, leaving those affected in limbo, they have in some respects positively made things worse. The EU 27, for broader political reasons, refused to make either a clear high-level political declaration or to engage in technical discussions, even at an informal level. Either would at least have...
just speak slightly slower for the few people that are getting translation.
I apologize.
I know everyone speaks English, but
yeah, I understand.
Just slightly slower. Thank you.
The EU 27... and I understand the political reasons behind that, but I still think it's regrettable, did not make a high-level political declaration or engage in technical discussions. Either would at least have conveyed some urgency. Meanwhile, that refusal to engage by the EU 27 gave the UK government cover to claim that it could do nothing until negotiations began. This claim was, at best, disingenuous. In my view, it was simply a convenient excuse to avoid addressing the complexities which other speakers have discussed. And still worse, the completely unconscionable treatment of some EE nationals who have sought to register their right to permanent residence, again, Muzdonsky described that, has quite understandably greatly exacerbated the concern of this group as a whole. Moreover, this has poisoned the atmosphere and ensured that, with good reason, to be quite frank, there is very little trust on the part of EE nationals in the UK, the Commission, or the EU 27 in the UK government's willingness to deliver on any promises made, if those are only at a general level. So, given that, the Commission's negotiating guidelines, assuming they are approved by the Council, are a very welcome positive step, and they offer an opportunity to press the reset button. They call the UK government's bluff by putting forward a detailed set of propositions that would broadly, of course there's a lot more detail to be done too, that would broadly guarantee all rights, both to EU 27 nationals and UK residents in the rest of the EU. I think this of course, and I think it's important to highlight that what the Commission has put forward is precisely what Vote Leave including the current British Foreign Secretary Boris Johnson, promised to UK citizens abroad and to EU residents in the UK before the referendum. So while it is in some sense a maximalist position, it is also the position that was offered by a number of those now in government who campaigned for Brexit. Meanwhile, the UK's position remains unclear. The UK has consistently stated, and I welcome this, and this I think it's important to recognise this is a sincere position on the part of the UK, that it does want to guarantee residents' rights on a reciprocal basis. But it has been vague at best on the question of when the cut-off date should be, and importantly on the legal guarantees to attach to other rights, especially family rights. It appears, as far as one can tell, to want a political commitment to residents' rights and perhaps to access to healthcare on a reciprocal basis, but little or no detail on other important rights, and no ongoing enforcement mechanism beyond that which would be set out in domestic law subsequent to the withdrawal agreement. So, where are we now? In my view, the EU27's proposals represent a good starting point, but I do think it would be sensible for the EU27 to recognise the UK's legitimate concerns in two areas. First of all, and Mr. Durfel again alludes to this, at present EA nationals have more rights than UK nationals as regards marriage, in particular to non-EEA nationals. It's going to be very difficult for the UK government to explain why, post-Brexit, EE nationals continue to have more rights than UK ones. This could be resolved by levelling up, but again, I think it is incumbent on the rest of the EU to recognise that the UK government will have significant political challenges in adopting that approach. So I'm not necessarily suggesting this is something that should be abandoned completely, but it is, I think, worth recognising that the UK government does have legitimate constraints on this score. Second, continuing the indefinite jurisdiction of the ECJ over the UK is unlikely to be acceptable to the UK. I think, for the reasons I said, the desire of the EU27 governments for some supranational supervision of the UK system, given the behaviour of the UK so far, is entirely understandable. But allowing a court in which the UK will not be represented in future to continue to make important elements of domestic law for several million people for an indefinite period, possibly up to a century for children born to EEA national parents in the next 2 years, does not appear to me to be reasonable. So resolving this issue will require immediate action from both sides and a constructive approach to the negotiations. So here is what I would propose. First of all, the following immediate actions to be taken as soon as the negotiations begin, on June the 8th or soon thereafter. A joint political declaration making absolutely clear that everyone agrees that any new system will enable, at a bare minimum, all EU citizens resident in the UK on Article 50 day and all UK citizens in the EU to eventually acquire permanent residence, and that nobody will impose complex or bureaucratic restrictions on this right, and that all existing rights will be guaranteed for an extended period post-Brexit. This won't prejudge the eventual agreement. It would represent compromise on both sides. It would build confidence, reassure citizens, and create a constructive atmosphere. Second, I think we should decouple this dossier from other elements of the withdrawal agreement, in particular the issue of financial obligations. This would not in any way undermine the EU's position that the principles of the withdrawal agreement, all those principles, need to be agreed before commencing talks on the future relationship, but it would ensure that citizens' rights were not held hostage to disputes over financial issues. Third, the UK government should unilaterally suspend the current process for permanent residence. It should set a target date for the introduction of a new, streamlined system and allocate resources for that. It should announce now that those new criteria will not include the current burdensome and legally questionable requirements for sickness insurance, will not require applicants to surrender their passports, and will shift the burden of proof as regards continuous residence from residence to the Home Office. This would do an awful lot to restore the confidence of EU citizens in the process. So that's what people should do, what all sides should do now. What then would a final deal look like? Here, I think there is, as I said, a lot of detail to look at, to work out, and I'm not saying that what I've set out here answers all the questions by any means, but I think it suggests an outline. First of all those resident on Brexit Day who have at least some period, perhaps 2 years, i.e. Article 50 day, of permanent residence should be offered a new status under domestic immigration law. The qualifying criteria should be interpreted liberally. That is, again, burden of proof on any national authority seeking to disprove this residence would be with the government, not with the citizen. All those with this new status would have all rights under EU law preserved for, say, 5 years after Brexit Day. And at least for the UK, an independent enforcement mechanism with representatives both of the EU27 and of the UK legal systems, which would follow existing EU law and ECJ jurisprudence, but which would be able to interpret the withdrawal agreement in relation to the specific issues covered. This, I think, would offer comfort both to the EU27, to citizens, that it wasn't simply the UK government unilaterally taking decisions on how the rule should be applied without enforcing ECJ jurisdiction or the continued jurisdiction of a non-UK court for the foreseeable future. After that period of 5 years, those with those status who were still resident, again interpreted liberally, would have the choice either to acquire citizenship of the country in which they were resident, in which case they would be treated fully and equally as other citizens in all respects, or permanent residence under domestic law, under at the very least the same basis other third country nationals guaranteed permanent residence, included as a minimum unrestricted work rights. And finally, all EEA states and the UK would commit, initially at a political level, to eventual full recognition of dual citizenship with no adverse impacts. In some member states, that would require a change to domestic law. That is to say, no dual national would lose any rights in respect of their original citizenship as a result of acquiring citizenship of another country in the EEA or the UK, either now or later. So, as I said, I don't think that I have all the answers here, but as something which represents a degree of compromise on both sides, provides the assurances citizens need, lets people get on and plan, and reassures most of all those people directly affected that their status will remain unchanged for a considerable period, and that will be guaranteed by international law. I think this represents a way forward. So to conclude, the EU27 and the UK have a responsibility to citizens who in good faith chose to exercise their free movement rights. So far they failed to do that. The start of the negotiations offers a chance to remedy that, but it's going to require goodwill and compromise on both sides and a determination to put people before politics. Thank you.
Thank you very much. And now time has come for me also to wholeheartedly turn to the experts and thank you for your contributions. You have managed to put on the table many important and extremely complex issues. Now we will have the opportunity of listening to our British petitioners, Ms. Banshaw and Ms. Wilkinson, who have used their right, as a right of any European citizen, to turn to the European Parliament and to the Petitions Committee. You're here today with us. I'm very happy for that. And now please tell us about your situation and the requests that you have. First of all, we'll listen to Ms. Leona Banshaw. Please, the floor is yours.
So first, I'd like to thank the Parliament and the Committee on Petitions for inviting me to this hearing. When I lodged my petition just after the Brexit vote, I never imagined that one day I'd be here discussing it in front of all of you. And as a great enthusiast of EU law and the European Union for many years, this is a great honour. It is also a great honour for me to say that I am a British citizen, because alongside that nationality, I have citizenship of the European Union. Therefore, my petition argues that the EU must also stand up for the rights of the British living in the UK whilst conducting the Brexit negotiations, as we face the loss of our EU citizenship. The Court of Justice has recognised that citizenship of the Union is intended to be the fundamental status of all its members, and that citizenship confers on us a number of additional rights and protections which are of great value and importance. In the case of Zambrano, the Court of Justice also acknowledged that no cross-border element was necessary in order to evoke the protection under EU law for its citizens. Therefore, there is a duty to protect every EU citizen within the Member States, including all the British citizens living in the UK who now face the involuntary loss of their EU citizenship. The UK's referendum on whether to leave the EU resulted in 52% of the referendum voters wanting to leave and 48% wanting to remain. This result only accounts for the adult citizens who voted and does not include the entire view of every British EU citizen, a large percentage of whom include young people below the age of 18. That means there are a substantial number of European citizens, either who had no voice on whether or not to leave the EU, or those that did chose to say remain. The consequences of Brexit for the citizens of the UK are that we cease to have our rights of free movement, which are the most fundamental of rights established under the treaties. We also no longer have the protection of our fundamental rights under the Charter. In addition, we are deprived of our status as EU citizens, which confer these rights on us. The EU also loses a member state, and the ever closer union begins to erode. So what can be done? Well, an agreement could be reached to put in place a transitional law that guarantees all pre-existing British EU nationals their rights under EU law. Upon final departure, if it is to be, then perhaps the solution is to have a cut-off date so that any newborn British or recently naturalised citizen would not have union rights. This is a principle that is familiar to nationality law in the UK, where it is possible to have a different right to nationality depending on when and where you were born. A deal that allows all current British nationals to retain their EU citizenship does not give us a better deal on departure. It does not give other member states an incentive to leave, because no new citizen of Britain would benefit in the future. We would be the long-lost children of the EU. In fact, a deal like this, where the EU has stood up for all of its citizens, shows exactly how committed the EU is in upholding its pledge to protect the rights and principles enshrined in its jurisprudence. The benefit of membership is clear. Once a citizen of the Union, you know that the EU will rigorously uphold and defend your rights until the bitter end. Our national government has acted irresponsibly and recklessly in offering the referendum in the first place, it being the result of infighting within the Conservative Party. The referendum campaign was tainted with deliberately misleading statistics, racist propaganda, fear-mongering, and lack of information about the real causes of people's dissatisfaction. The result is that every British citizen is punished with the loss of the most fundamental of freedoms that the EU has pledged to uphold and protect. As an immigration lawyer, I have used European law to change people's lives for the better. I know how powerful a defender of fundamental rights it can be. And many people simply do not realise what protections they have through their citizenship of the Union. You see, I value my right of free movement, and it is something that many people I advise would give anything to have. Yet there are those who are now so ready to throw it all away. There is no one left to uphold these rights for us. In fact, the Conservative Party's manifesto is expected to pledge an end to free movement rights. And that, in turn, means my rights and my fundamental freedoms. I fear the future without the protection of the Charter or the treaties and directives. Will it be the case that no longer will I or any other British citizen be able to rely on the powerful principles of direct or indirect effect in our national courts? Will we no longer have recourse to the European Court of Justice, which is of vital importance at a time where we have a government so keen to erode our rights of privacy? And it's here that I must give special thanks to the Court of Justice for their recent decision in December, blocking many of the invasive provisions in our so-called Snoopers Charter. Of course, the great irony in this being that the case itself was referred to the EU Court by David Davis, the current Brexit minister. I also fear a government that explicitly wants a hostile environment for migrants, with huge visa fees and medical surcharges. A fate that may now befall on all the helpless EU citizens. Here, I must also remind the Parliament and its members of the British citizens that have or are currently exercising their rights of free movement in other EU countries, who also stand to lose the benefit of their rights under the EU regulations when returning to the UK with their family members. And finally, I fear a government who want to replace our human rights with a British Bill of Rights, whatever that may entail. At least as a Union citizen, I had the comforting knowledge that my rights in the Charter were there to echo those in the European Convention on Human Rights, should a government wish to replace or dilute them in the future. It was kind of nice to know that you were there if I needed you. If ever there was a need for the EU to stand up for its citizens, it is now. To stand up for the British EU nationals who face the ultimate member state breach, the entire loss of their fundamental freedoms. So, please don't leave us adrift when we need you the most. Therefore, I ask the Parliament and the EU negotiators not to forget about all of its citizens. And I implore you not to forsake us British just yet, and to fight to guarantee our rights in this Brexit disaster. Because as of today, we are still the EU 28.
Thank you very much. Yes, we are indeed still the EU 28. I'm now happy to turn to Anne Wilkinson, and the floor is yours.
Thank you. Distinguished members of the European Parliament, ladies and gentlemen, thank you for inviting me to explain my petition to you this afternoon. It is very encouraging to hear such warm concern on the part of not only the Parliament but also now the Commission and the other 27 remaining member states for the interests of European citizens and for the concern that there is for the loss of their rights. Guaranteeing the rights of citizens is now the first priority in the forthcoming Article 50 talks. Nevertheless, the fact remains that citizens' rights fall to be decided within the framework of a difficult negotiation whose outcome is far from certain and in which nothing will be decided until everything is decided. My petition, number 13217, asks Parliament to consider an alternative approach to the problem. In it, I argue that the rights of EU citizens, once acquired, cannot be withdrawn under EU law and are therefore not appropriate to be included as subject matter for negotiation between the EU and a withdrawing state. My argument is based on the jurisprudence of the Court of Justice and on the treaties. Long before the treaty introduced the concept of European citizenship, the Court had defined the European Economic Community, as it then was, as constituting a new legal order of international law, the subjects of which comprise not only member states but also their nationals. Independently of the legislation of member states, community law is intended to confer upon them rights which become part of their legal heritage. And of course, I'm quoting from the well-known case of Van Henen-Loos. In creating the Union, 30 years later, the treaty fundamentally changed the nature of these rights by creating a direct political link between the citizens of the member states and the European Union. To qualify for citizenship under the treaties, then as now, an individual must have the nationality of a member state. The acquisition of citizenship is automatic. The individual cannot refuse, decline, or reject it. Once acquired, citizenship is additional to the qualifying nationality. And additional is a very deliberately chosen word. The Nice version of the treaty in 2002 spoke of citizenship as a complement, but the word additional is used in both the current versions of the treaties. The acquisition of citizenship, in my argument, is distinct from the rights that flow from its possession. Those rights are granted constitutional status by being enshrined in the treaties themselves and do not require the intervention of a member state. Directive 2004/38, the so-called Citizens Directive, emphasised the direct link between the Union and its citizens, stating explicitly that the rights of freedom of movement and establishment are fundamental, personal, and emanate directly from the treaty without the need for any administrative act. The directive was largely a codification of the Court's jurisprudence on the subject to that date, and the Court has continued to develop the law in this area, interpreting the scope of citizens' rights generously and attempts to limit them restrictively. Once a member state leaves the Union, its nationals will no longer have the necessary qualification to acquire EU citizenship. But I submit that the unilateral withdrawal of a member state is insufficient of itself to strip citizens of rights already acquired under EU law. The rights granted by the treaty can only, I submit, be revoked by the treaty. The treaties make no provision for the resignation of a citizen, or his expulsion, or for the confiscation of those rights that are part of his legal heritage. Limitations can be imposed on their exercise, and the court will interpret them restrictively, but not on their existence. The treaties provide for further strengthening of their provisions on citizens' rights. Nowhere do they envisage their extinction. Article 50 provides that the treaties will not apply to the state after its withdrawal, but is silent on its existing citizens. The current text of the Commission's negotiating directives provides that citizens' rights should be protected as directly enforceable vested rights for the lifetime of those concerned. That goes a long way towards my argument. But guarantees to that effect are subject to reciprocity and to the outcome of the agreement as a whole. In the best case, that leaves Europe's citizens in doubt for almost 2 years. From a practical point of view, the need for clarity on the issue is pressing. Both sides entering the Brexit negotiation need to know what horses they have to trade. Their citizens should not be included in the count. My petition therefore asks the Parliament to request the Court for an opinion under Article 218 TFEU as to whether the EU is competent to negotiate the individual rights of European citizens as part of the Brexit agreement, or whether as part of the individual's legal heritage they cannot be revoked and are therefore non-negotiable. That is consistent with the 11th paragraph of Article 218. A member state, the European Parliament, the Council or the Commission may obtain the opinion of the Court of Justice as to whether an agreement envisaged is compatible with the treaties. Where the opinion of the Court is adverse, the agreement envisaged may not enter into force unless it is amended or the treaties are revised. The Court has held that where a question of competence has to be decided, it is in the interests of the community institutions and of the states concerned, including non-member countries, to have that question clarified from the outset of negotiations and even before the main points of the agreement are negotiated. The only condition to which the Court referred is that the purpose of the envisaged agreement be known before negotiations are commenced. That is the International Agreement on Natural Rubber in 1979. And there is a more recent authority to the same effect in 2011 on the International Agreement for Patent Litigation. Based on its jurisprudence over the past 55 years, I submit that the Court would in all likelihood declare the question admissible, and if so, the test it would apply to the involuntary removal of rights conferred and protected by EU law would be a test of proportionality, taking into account the consequences that the decision entails for the person concerned, and if relevant, for the members of his family, with regard to the loss of the rights enjoyed by every citizen of the Union. What would that mean for the negotiation as it stands? First of all, I submit that it would simplify it, because by making it clear that EU citizens' rights were inalienable, the only thing left to be negotiated is the manner in which the United Kingdom safeguards them. Now, you may say that gives an unfair advantage to one side over the other. But I would say this: consider the ultimate objective at the end of the Brexit. Is the EU's final objective to say goodbye to the United Kingdom? That's it. Tant pis. Or do we envisage a happy future in which the United Kingdom rejoins the European Union as a fully committed member of a fully functioning European Union? In that case, I remind you of the importance of keeping the young people in the United Kingdom on board the European project. Last year, the age group that was most in favour of remaining within the European Union were the group between 16 and 24. Not all of them had the vote. The vote was, the eligibility limit was set at 18. But in a few years' time, it will probably descend to 16. If it takes 10 years for the country to be ready to review this question, those young people who in 10 years' time will be between 16 and 24 are now between 6 and 14. And they will be growing up in a completely different environment than that which gave their older brothers and sisters such a positive view of the European Union. Members of the European Parliament, ladies and gentlemen, thank you for listening to my petition. I commend it to you.
Okay, thank you, our expert speakers and our petitioners. Thank you very much. I make no comment because we're running over time, but you can see from the reactions how much your contributions were appreciated. We are running over time, and we're going to come to our members of the European Parliament to react to all of these comments and to make statements of their own. But just before we do that, we had agreed to give a very short moment to two organisations. New Europeans, a civil rights organisation which champions freedom of movement and so on, and also we heard earlier about the British in Europe. And I'm going to ask them to strictly stick to 4 minutes each. Please help me by sticking to 4 minutes each, please. Unusually, because there was broad agreement that we would give you the floor. So we start with New Europeans. And Saima, please, from New Europeans.
Yes, thank you very much. I'll try to be as short as possible. We've got a briefing which we have circulated with a lot of research, so we're happy to circulate this further. I just want to start with something that I heard yesterday from the UK government saying that they will negotiate the rights of EU nationals one by one. We found this totally unacceptable. And one of our members, who's Professor Emmy Vanderson, who's the principal of the New School of Psychotherapists and Counselling.
Just sit back from the microphone.
Sorry.
Thank you.
Has said that there is an increasing concern among psychotherapists in the UK over the deteriorating mental health of numerous EU citizens who have been under considerable emotional pressure for the past year, as their previous safety and continuity of residency are at risk, and they experience being treated as second-class citizens. Their levels of stress have increased dramatically. The UK government and the EU have a moral and legal duty to address this alarming and inequitable situation forthwith. I want to quickly talk about the good, the bad, and what can get better. So I want to thank the EU and for the position you've taken in terms of championing the right of citizens. Living in the UK, the word EU is really a bad word, and usually people tell us the EU doesn't do anything about their concerns. So on behalf of the citizens, the millions of EU citizens that we represent, thank you. But these are exceptional circumstances. There are no rule books. We want the EU to take a step further. We need the EU to be extremely brave, ambitious and bold, and we believe that there's a case, a moral, legal and political case for unilateral guarantees to be given now to UK citizens who live in the EU. From a political point of view, this would put the UK in a very untenable position. And similarly as the Brexit bill, we believe our rights shouldn't be negotiated, and the rights of citizens should be a precondition to the start of EU negotiations. So we would look for EU institutions to consider the possibility of making those rules. Very quickly, over 44% of EU nationals in the UK no longer feel welcome in the UK. This is a great concern. There's an issue with community cohesion. Sadly, the UK government is doing nothing about it. But at local level, such as in regional level like London, EU citizens have been made welcome. So I'm going to quickly give you the recommendation in terms of improving the process of registration. We need clarity on CSI requirements. We find it unacceptable that there's a legal position from the Commission that our rights are being breached. There's nothing we can do about it, and there's no interim relief for EU citizens who are entitled to NHS and claim permanent residency. So we ask for Parliament to support and to put pressure on the Commission to explain what the interim position is for those millions of EU citizens. We want the UK to simplify their system and make sure that there is remedial action when claims are defective, and for the UK government to be proactive and to be providing the evidence. We also have evidence from UK citizens in the EU having problems, so we suggest that we look at harmonisations of those processes, because permanent residence is acquired and should not be, there's no need to apply for it. I'll pass the mic to my colleague.
You have about 4 seconds.
Very quickly follow this up by saying that the argument for unilateral recognition is also backed up by the right to private and family life as enshrined in the European Convention on Human Rights. And that is an aspect, the international human rights aspect of this debate, that unfortunately has not been picked up enough, and we must stress that the EU27 and the UK will be bound, are bound by the European Convention on Human Rights, and are therefore must give recognition to the right to private and family life as soon as possible, hopefully through the resolution that Guy Verhofstadt has made reference to.
Thank you very much. That was the New Europeans, and now for up to 4 minutes, Jane Golding from British in Europe, please.
Yeah. Thank you very much. I really appreciate this opportunity to speak on behalf of British in Europe, which is a coalition of 11 UK citizens groups across the EU. Like EU citizens in the UK citizens in the EU have been living with huge uncertainty for more than 10 months now, unable to make decisions about their personal and working lives. They've been living in limbo. For some, the more vulnerable among them, especially retired people, the strain is taking their toll on their health. And it should be remembered that the majority of these UK citizens were not actually able to vote in the EU referendum. So for these reasons, British in Europe, our coalition, welcomes very much the European Parliament's negotiating guidelines and the negotiating guidelines adopted by the European Council on the 29th of April as a huge step forward in obtaining the majority of rights that we're seeking to safeguard, as well as the detailed draft negotiating directives set out by the Commission. We're also very welcoming of the transparency with which the EU is proceeding. We drafted an alternative white paper shortly before the UK government's white paper was published back in February. And what our chief objective is to ensure that individuals are not affected retrospectively and adversely when the UK leaves the EU. That's UK citizens in the EU and EU citizens in the UK. Like EU citizens in the UK, we've all moved in good faith to another EU country, relying on our EU citizenship rights, and in particular our right of free movement. So the issue is an issue of fundamental justice for both of these groups. And in our view, citizens should thus continue to have all the rights that they had acquired or were in the process of acquiring while the UK was in the EU. And just to be clear, simply confirming a right of residence is not enough, and that is why we are very happy that the negotiating directives make this clear. So, for example, having the right to remain as a professional living in Germany, such as I do, doesn't help you at all if your qualifications are not recognised because you don't have your right to work. Similarly, for a pensioner, an economically inactive person who doesn't have access to health care but has the right to remain, this doesn't get you very far. As Michel Barnier said in his Florence speech last week, all 4.2 million citizens affected should be able to live their lives as if Brexit never happened, and that is what we would like. Because after the referendum, everything that we had relied on, everything that we had taken for granted, the basis on which we had made our lives was pulled away out from under us. We're therefore asking both the EU and the UK to adhere to our core governing principle, which is that citizens are not affected retrospectively by the UK leaving the EU. And I should just comment on one of the interventions from the panel from Jonathan Portas. I would argue that citizenship is not a panacea for everything. As I've already mentioned, there'd be the problems with professionals, mutual recognition of qualifications. There's lots of complex issues which are not covered by acquiring citizenship. Thank you very much.
Thank you very much. Thank you to both organisations. We now come to our members of the European Parliament, and if you haven't indicated yet, please indicate, and I'm very happy to hand this management over to Renate Weber.
Yes, thank you very much. We are, in fact, behind the schedule. So I already have a list of 13 members, and I'd like to know who else would like to take the floor. And, okay, 14.
Best thing is
yes, you are on the list. You are on the list.
Best thing is just everyone indicate now.
Yes.
Just everyone indicate now. That's it. In one go.
I think you are
we don't want
all
to miss anyone.
on the list. Yeah.
Okay.
So I can close the list, but I have to deeply apologize. It's a maximum of 2 minutes for each of you, because indeed the time is already pretty late. The first one, Sophie in 't Veld, please.
Yes, thank you, Chair, and thanks to everybody who gave testimony here this afternoon. I think this is a very important opportunity for citizens to have a voice and to have a podium. I have been very affected by all the personal stories that I got over the last months. And I was thinking, we're talking about it as if it's a legal issue, but it's not. It's not a technical issue, it's a moral issue, an issue of humanity. And if you put things in a slightly different perspective, say there is a mid-sized country in the world of between 15 and 20 million people, where people have no basic human rights, there's no legal certainty, your family can be disrupted at any moment, you can be deported, you can lose your job, you can lose your qualifications from one day to the next. What would we call such a country? We'd call it a banana republic at best. It could never be a member of the United Nations, the Council of Europe, or the European Union. So why do we think it's acceptable that we treat EU citizens this way? If we're a community of values, then this is the moment to prove it. Now, we tend to get distracted by details, and yes, details are important, but we need to take a step back and look at the fundamental issues, because the disruption of lives is not unavoidable. It's not like the weather. It's a matter of choice. It's in our hands. It's in the hands of the government leaders. Therefore, I feel that apart from all the negotiations, resolutions, agreements and what have you, people need to get the absolute guarantee from all governments that nobody will be forced to leave after Brexit. Not forced by law and not forced by circumstances. And giving that assurance is not a matter of politics, it's a matter of choice, a matter of political will, and political leaders can choose to do so. Two final remarks. The details of the conditions and the rights of continued stay can be settled in an agreement to be negotiated. I'm very pleased that this will be the first issue to be addressed, that is in very good hands with Guy Verhofstadt. And of course we have to follow the rules. But I do feel that there has to be some sort of contingency plan for the 5 million people and their families in case the process collapses. Because then we cannot say, well, sorry guys, we tried. And finally, I would suggest here to the colleagues that we organise a follow-up of this hearing, maybe sometime just after summer, when we have a clearer picture of what the situation will be like. We may have the resolution on the table. And I think the European Parliament should continue to give this podium, give voice to the citizens of the Europe of 28. Thank you.
Thanks a lot, Sophie, also for the suggestions, and I'm sure that will be followed indeed by other such hearings, because I think it's important, although some of the reports we hear today were really scary, let's be very honest. Mr. Richard Corbett, the floor is yours.
Thank you. This hearing has shown that the consequences of Brexit are dramatic for citizens, far more so than was apparent at the time of the referendum nearly a year ago. It seems to me that there's only one way to be certain of retaining not just the rights of residents, but the other important rights that go with that we've heard about, and to be absolutely certain of retaining it. And that is, of course, to stop Brexit. A country can change its mind right up to the last minute, and I hope that those of you who have come here today from the United Kingdom will have joined organisations like the cross-party European movement that are still campaigning to stop Brexit. But if Brexit goes ahead, any agreement reached, whether it's the divorce deal under Article 50 or any other agreement reached with the United Kingdom, for instance, a separate agreement on citizens' rights, must, as a matter of EU law, be compatible with the treaty, including the Charter of Fundamental Rights. So any agreement that falls short of that in terms of guaranteeing the rights of citizens can indeed be challenged at the Court of Justice. There was a suggestion from one of our, from I think Mrs. Wilkinson earlier, about a particular way of challenging it. And then that's an interesting one I had not heard of before. But certainly the deal itself, including the Article 50 divorce deal, Parliament, apart from its right to say yes or no to that deal, has the right, if in case of doubt, and there may well be doubt, to refer it to the Court of Justice to say, is this compatible with the treaties and the Charter of Rights? And we must make sure we keep that option open, because it's the Parliament that defends citizens, and it's our duty to do so. Thank you.
Thank you very much. Catherine Bearder, please.
I'm speaking really for two of me, but I wouldn't expect 4 minutes. But Charles Gorin had to run. He has a meeting in Luxembourg this evening. But he asked me to say how much he welcomes this hearing and how pleased he is to see so many people here, and I'm sure as many, many more online that are watching that. He wanted me to convey to you how very concerned he is about the plight of EU nationals in the UK and British citizens elsewhere. And he wanted me to say to you that we will do what we can for you here in the Parliament, but he felt the EU cannot let down the millions of people that are affected by that, and he said it doesn't have to happen like this. We must work towards mitigating it or stopping it, and for that I will concur with him. I think we can stop Brexit if in its tracks when the full reality becomes clear. I'd like to thank Guy for his intervention too, and the many speakers. I've been feeling, as a British subject here, torn. You know, half the time I'm feeling embarrassed because of the British government, but very proud that so many people have come here to speak so well. this is not just one issue either. I think this is, I don't need to tell Guy this, there are so many complex issues that is going to go on. And what I feel is that time is not on our side. We only have about 18 months. There is time to negotiate. Careful negotiations take time. We need time to untangle the interface of two legislative systems and untangle people's lives that they've built up over the years. And we need time. The people who are putting in the forms and the applications need time to have those dealt with. We hear over a year for some people, and that is not acceptable. So it's so complicated. UKIP are here today. They told the electorate during the referendum that it would be very easy. We could just leave, and they had a plan. I'd love to hear what their plan is. It certainly hasn't come to light yet by any Brexiteer. And I'm also very disappointed that the British government didn't feel that they could come here and do a presentation either. And I suspect that is because Mrs May has a horror of the ECJ. That is, Guy, how they will be protected citizens in the future, and that is something that really frightens the British government. My real fear, though, is that the policy of nothing is decided until everything is decided. We have to decide this first and very quickly. Then we can get on with the rest of the negotiations. Thank you.
Thank you, Catherine. Beatriz Becerra, please.
Gracias, Presidenta. Yo voy a hablar en español.
Thanks very much, Madam Chairman. I'll be speaking Spanish. And first of all, I'd like to extend my deepest and warmest thanks to our experts who've come along this afternoon, to the associations, and particularly to the petitioners. I think it was great to hear you witness. You're very brave and come forward with very cogent arguments. That makes us feel stronger in the EU. And it goes directly to the topic that was not discussed in Brexit, citizenship. This catastrophe had to happen before we started talking about citizenship. We had to reach this moment where everything is up for grabs, where we realize that damage to citizens and citizenship isn't just a side issue or collateral damage. People who've complied with the rules, who've acted in good faith, cannot retroactively foot the bill for a unilateral change to the rules. All of this information, all of these proposals we've heard this afternoon are extremely valuable. I'm very grateful to Guy for his clarity. And I think it's possible to move forward and to place a cordon sanitaire, as it were, to ensure that we preserve the rights of citizens. There are all sorts of issues such as the interpretation of the legal government of the minimum income threshold. It's highly legally questionable. I think it's in breach of the law, and I think we should bear in mind any court ruling on this. All citizens, not just in the UK. And let me draw attention to one point I think we need to look at. There is increasing harassment in the British press. They are perverting language. They're starting talking about European privileges rather than European rights. I think that needs addressing. The European Parliament and all European institutions are committed to these issues. We're in the front on this, and we're going to stand shoulder to shoulder on these issues. Thank you.
Mr. Ellen Smith, the floor is yours.
Thanks, Renata. I'd add my own thanks and welcome to the petitioners and the experts. It's good experts do have an audience in some institutions, politically at least. You're very welcome. You've set us a challenge. And like your testimony today and others, I'm receiving emails, messages on a daily basis that break my heart. This is not a dry academic exercise. This is real lives of real people. And we've been set a challenge, and colleagues, we need to rise to that. And I'm not sure we have thus far. I don't think the European Union has served the rights of our citizens as well as we need to do. Now, there's been intransigence on a number of parts domestically, but we need to step up. I'd also urge colleagues, before we get lost in the minutiae of this, remember that there is a very lively dynamic within the UK. There are a number of us within the UK who still oppose Brexit. I'm coming from Scotland, but there are others across the UK. But it is the view of the Scottish Government, Parliament, and 48% of those who even participated in the EU referendum that the best Brexit is no Brexit. And I won't be approving and voting for any resolution of this House unless we see a lot of changes that does approve Brexit, because I don't think there's a good way to cut out your own heart. So remember that dynamic within the UK. Brexit is not inevitable. This is not fixed. This is built on sand. So in terms of what we need to do, and the question that I think we need to answer is the EU a club of states, or is it a union of peoples? Thus far, we've seen a lot of club of states stuff, and I don't think the citizens have been as represented as we need. What we need to change the weather on this is a unilateral act of generosity. Citizens' rights are the top priority. The UK government, the Scottish government, the EU side, great. Let's see the unilateral act of generosity that will actually move things forward. On past records of Theresa May as Home Secretary and indeed as Prime Minister, I don't think we're going to see that from the UK government. If we agree that that act of generosity is in the interests of our citizens, surely the call should come from our Parliament for that unilateral act of generosity to guarantee the rights of UK nationals across the EU. Now, set a date, find a way to do it. That will put, I hope, intolerable pressure on the UK government to change its tone, to change its rhetoric, and to match that ambition and generosity. So there is a very lively debate on this, and I absolutely concur that we should suspend the principle of nothing's agreed till everything's agreed. This is too important. Let's do this first. I think we can do this first. There's lots of legal stuff to be worked out, of course, but I think we're up to it. We've got the experts. What we need is the political will, and I don't think we've seen the political will from the member state governments thus far. Surely it's up to the European Parliament to be that voice. Thank you.
Thank you very much, Mr. Dance. The floor is yours.
Thank you. I'd like to associate myself entirely with that in terms of raising our ambition. I'd also like to thank the petitioners for their very eloquent presentations. Indeed, there are two sides to this coin. In fact, there might be a third dimension, as Mr. Verhofstadt pointed out. Maybe that's the circumference of the coin, not to labour the metaphor too much. But we are, of course, talking about citizens on both sides of this, EU 27 in the UK, and I'm very pleased that the British in Europe voice was heard earlier as well for the UK citizens in the EU 27. I want to echo what has been said about this as a key moral issue, as a point of natural justice, because, of course, we are talking about people who have made decisions, life decisions, and moved where they live, work and contribute based on existing rights and responsibilities that have been given to them by virtue of being EU citizens. Effectively, we're talking about a process that changes that position without, in many cases, in fact, in most cases, without the consent of the individuals involved. 10 months is an incredibly long time for anybody to live under a question mark and a cloud of uncertainty. When you come across key milestones in your life, whether it be points in your career or points in your education, you have no choice but to make decisions there and then. You can't put them off for a few months, let alone 10 months, and of course 2 years is unthinkable. And that's why I think what we have heard from all of the evidence that we've heard today is that it is so important that we remove citizens from the process of the negotiations so that they become out with the toing and froing, and whatever your position in the referendum, whether you were for leave and remain, and I know there are some people here who did advocate leave, that we agree on this one point, that citizens come first. And that's why the principle of nothing is agreed until everything is agreed should be suspended for the citizens that we're talking about. It's their lives, and it's not fair on them to have this question mark hanging over them.
Thank you. Tatiana Ždanoka, please.
Yes, thank you. I want to refer to just to two petitions. And the problem was raised in this petition is just automatic loss of EU citizenship as a result of loss of citizenship of EU member state. And to my regret, it is also our mistake, a mistake of the European Parliament, that we did not change the situation. And Mr. Verhofstadt, you told, and our petitioners think also that EU citizenship is additional to member state citizenship. but all practice shows that it is a simple derivative of member state citizenship, and the situation was not improved by the report of Catania. Claude Moraes has to remember it was in the legislature after enlargement. There was a report on citizenship and it failed. We lost very, very few voices to have a majority. Then my own opinion have been lost in Libe Committee on citizenship. The same thing in next legislation, also by one vote, I guess, I'm afraid, from GUE, who told it's too federalistic. Yes, because we proposed just this EU citizenship not to be a direct derivative from membership, member state derivative, but just additional thing which cannot be lost automatically if you lose EU citizenship, member state citizenship. So we have to learn from our own mistakes. And you, Mr. Verhofstadt, have your report on further legislation in this issue. Of course, it is also treaties, but I hope at least our parliament will now have a majority for the concept that it is EU citizenship is something complementary, just complementary to member state citizenship. And we have to discuss it. I hope Libe will initiate this issue of EU citizenship in the nearest future. Thank you.
Thank you, Tatiana. And we go now to Ms. Judith Curtin-Darling, please.
Thank you very much, and thank you very much to all the speakers, particularly to the petitioners for coming today. You've displayed exactly how Kafkaesque the situation is for many citizens across Europe now, whether in the UK or in the rest of the EU. And I think that supports what we found regionally in the northeast of England post the referendum. We undertook a widespread public consultation of Leave and Remain voters to establish why our region voted 60-40 to leave the European Union. And what came back were a lot of EU nationals who are living and working in the northeast of England who are very, very concerned, anxious, uncertain about their future, and in some cases fearful, very fearful. I'll give one anecdote. Newcastle is considered to be one of the best places to go out at night in the UK. We're considered to be one of the most welcoming regions in the UK. And yet a German professor at the University of Newcastle was asked by German students when they started on an Erasmus course at the University of Newcastle where the safe pubs to go were because they were fearful about anti-European reaction in the streets of the city. Now that, to me, is shameful. It's shameful that so much hate and so much fear was wound up during the referendum. And now we have a moral obligation to make sure that people don't live in fear, whether they live in the UK or whether they're UK citizens living in the rest of the EU. One very precise point to raise is something that we've talked about in the Petitions Committee a lot, and that's voting rights. Most of the people who we've heard about today had no vote on the decision which affects them singularly in the most part. EU nationals in the UK and many UK nationals in the rest of the EU who lost their voting rights after living abroad for more than 15 years. If there's one reason why we have a moral obligation to stand up for all of these citizens, it's because they didn't have a voice in this decision. And I think that makes the case for why the moral has to come before the legal. We have to find a solution. We have to find it quick. We should not have people living in fear and living with this level of uncertainty. Thank you.
Thank you. Mr. Button, the floor is yours.
Thank you, Madam Speaker. Well, the last few speakers have actually confirmed what this afternoon is really all about. It's about finding a way of reversing the referendum decision. And one of the ways to do that is endless negotiations. And as Mr. Varoufakis, the ex-finance minister of Greece, recently said, and he's a Remainer, by the way, he said, don't negotiate with the EU, they don't do negotiations. And he's quite right. Trying to leave by Article 50 and negotiating our way out is entirely the wrong way to go about it. The British government should repeal the 1972 European Communities Act and then tell the European Union how it's leaving, not ask them how it can be done. I have two questions, and then I'd like to say something briefly about citizenship. First of all, Renée Weber spoke about access to acquired rights and the benefit systems for EU citizens in our country. And also this time bomb of vested rights was raised, which was alluded to before, and it's a Court of Justice decision of 1963, which says the community constitutes a new legal order, etc. It not only imposes obligations on individuals, but is also intended to confer rights upon them, which become part of their legal heritage. This is a time bomb under the Brexit negotiations, which nobody in the UK is talking about, and the government certainly isn't. And indeed, Mr Verhofstadt spoke about protecting the rights of everybody, the economically inactive, the economically active, and anyone who has ever visited the EU. And he said they should have access to the NHS, access to education, etc., etc. Now, Britain has always been a net contributor to the budget. Out of 43 years out of 44, we've been a net contributor to the budget. In fact, we're normally the second, third, or fourth biggest contributor to the budget. Most of the countries who are members of the EU have never been net contributors. They are beneficiaries. And my question is, who is supposed to pay for not people who are already there and already established and have rights, but anybody who was actually born? I didn't interrupt you, don't interrupt me, please. Who is supposed to pay for people who may have visited the UK once? And the vested rights thing may actually apply to anybody born up until the time we leave the European Union. And considering that the eldest citizen of the EU died recently, aged 117, we might never be clear of this thing for 100 years. So my question is about fairness. Is it fair to expect British taxpayers to pay for that when they've always paid for the EU? Regarding the question of people living in the EU, it isn't true entirely, as Jonathan Porter said, that the Leave campaign didn't talk about it. I've been a Leave campaigner for 25 years, and I was an immigration spokesman for 5 years, and I said that this is going to be the hardest problem to unravel. But I did say that we need a reciprocal agreement, we need simplified systems, which have always been alluded to, so that everybody is sorted out very quickly. You can't enforce that across the EU because while the UK will sign an agreement and keep to it, we have to rely on 27 other states to keep to it. And I get people write to me all the time because EU law is not applied properly in countries and they can't get the Commission to do anything about it. We need bilateral arrangements with every one of those 27
can you
countries.
Conclude, please?
Very quickly on citizenship.
It's already, come on.
We agreed
on a rule of 2 minutes.
You all go over time, and I'm asking once. I normally stick to my 60 seconds, and I'm asking once for a little bit of extra time, like Mr Verhofstadt gets every time he speaks in the chamber. Very quickly, involuntary loss of citizenship.
No, I'm sorry.
No, it wasn't involuntary. There was a referendum.
Okay. I'm sorry, don't have a microphone anymore. Thank you. Ms. Diane James, please. So, regardless of your political views, you have been given 2 minutes each. So please, let's respect the rules, yeah? Thank you.
Madam Chair, thank you very much indeed. And can I thank all of my MEP colleagues who have spoken so far, and particularly the petitioners and representatives of the various citizens' organisations. What I heard this afternoon was very welcome. I had heard a lot of it before, don't get me wrong, but it's always beneficial to be reminded. I think two very important points have come out in the last 10-15 minutes. One is a request from an MEP colleague, Mr Dance, that could the issue of nothing is agreed until everything is agreed be suspended. I endorse that, but can I remind you, Mr Dance, that that is a hardline position taken by the European Union. But I endorse the request, and if you want support for that, you've got it. The second point was made was to ask for moral before legal. Again, I actually endorse that. That might surprise people in this room. But it's a hardline position. And Mr Verhofstadt announced this last week when he briefed AFCO that one of the key aspects of this position from the EU is ECJ oversight. So they're actually already saying it's got to be legal before moral. But again, if you want support for that, and if you can get the EU to drop the issue about ECJ oversight, you've got that in writing from me. Can I just ask, though, that next time we have a hearing like this, could we have a bit more panel balance? We heard some very interesting aspects from the experts. I'm not going to decry what they had to say, but I've heard some very cogent arguments and issues outlined by, for instance, Lawyers for Britain, which happens to be pro-Brexit. But I think it's important that anybody coming to a hearing such as this walks away hearing the other side and understands what the issues are. Please, I didn't interrupt anybody, and I'm not asking for you to interrupt me. I'm merely making an observation that this is not the first occasion where I've come to a hearing or in a committee meeting and I've heard the panel bias, and I don't think that's positive. But, Madam Chair, thank you very much indeed for this afternoon.
Thank you. Mr. Bornet, the floor is yours.
Thank you very much. Firstly, I would like to thank for organization of this hearing, and I think that we need to continue because it's very important for us, for members of European Parliament, to talk with representatives of organizations, universities, many people from UK, and discussing those issues. And especially I want to thank to those people who presented their personal testimonies. 3 lessons from this meeting, from my point of view. Firstly, I think it's important to understand what does it mean European citizenship. And due to this case, I think that we will start to understand better and stronger what does it mean European citizenship. Secondly, we are not talking about workers, professions. We are not only talking about details, we are talking about humans. And I think that for some people it should be clear before Brexit, before supporting Brexit, what kind of consequences, moral consequences and consequences for humans the Brexit will bring to all of us. And the third point, if we understand this connection, humans, many business issues, legislative issues, very complicated, we need to have our positive response from the European Parliament. So we need to work on this citizenship and citizens' rights in Employment Committee, in Libe Committee, in some committees together. Not to separate those issues, but to have this holistic view on those issues and support people on the side of the European Union, our citizens living in the UK. I'm from Poland. There are many Polish people in the UK, and also support UK citizens in their way to be under the fundamental rights, because this is our right at the beginning of the 21st century. Thank you.
Thank you very much. Jean Lambert, please.
Well, thank you, and I'd also like to add my voice to those who've been thanking the contributors this afternoon. I think we've heard some very clear, while very moving, sort of testimony about the realities of this. And one of the things that we hear quite a lot in the UK at the moment from some is that no deal is better than a bad deal on Brexit, and I think it's absolutely clear from what we've been hearing today that, if you may think that for the World Trade Organization, sort of tariffs or whatever, it's manifestly untrue when it actually comes to people whose lives, as people have said, have been in limbo. But when we're looking at safeguarding rights, I think we also have to recognise that this is a difficult climate. It's difficult in the UK. We have, in my view, a Prime Minister obsession about migration numbers. She's not alone in that. We're seeing this competition in the general election. And I don't think the UK is the only member state where that's an issue. And I think that's something that we should be making sure we recognise as a Parliament, because the excellent studies that were done for the Petitions and Libe Committee about the exercise of European citizenship in different member states show there are problems in a number of countries which need to be addressed in terms of permanent residence. And I also think that we should probably do a seminar session for a number of members in this Parliament about how social security rights are working across border, because those are acquired rights, they are historical rights, and people have contributed for them. So, you know, that wasn't national governments, that was individuals. So I do have a question about how we think this transition can be made, partly for people in employment who currently have jobs, if they're finding themselves moving in any of our member states from EU citizens to third country nationals, how we are actually going to support that process so that people don't have to leave the country to apply for their jobs to come back in again. And whether, also from some of our experts present, whether they think the UK government has actually had a consistent position on comprehensive sickness insurance. And isn't it about time the Commission actually challenged the UK government on that in the ECJ?
Thank you very much, Jean. Yes, Barbara Spinelli, please.
Ma ascoltando gli interventi straordinari dei...
Listening to the testimony of the petitioners, I thought about the responsibility of those who at the beginning of the referendum campaign didn't point out what a disaster was on the way. The highest share of responsibility belongs with the UK political class, who lied about the possibility of preserving rights, something which will be difficult if not impossible. But also there's responsibility here in the European institutions for not having insisted with sufficient force during the campaign about the risks which the country faced if it wanted to abrogate the European Human Rights Charter. It's a question now of trying to get back the time that's been lost and make sure that social and civil rights issues are tackled and sorted out at the beginning, because there's too much fear in the UK, and there's a danger that this fear will feed into a growing xenophobia. So I agree with Ms. Donskoy that the idea that everything's sorted out and nothing's sorted out until everything's sorted out is wrong. The question of rights needs to be dealt with first. And I also agree, therefore, with Guy Verhofstadt's proposal that we need a resolution in this House specifically about rights, which will put some pressure on governments and will get the UK and the citizens who are living in fear today, will tell them that we really are listening to them this time, that we're not going to pretend that we can't see the danger that's right in front of us. Thank you, Chairman.
Monica Holmeyer, please.
Zunächst einmal darf ich... First of all, I would like to say that I regret that a lot of good arguments weren't heard prior to Brexit, but there was lots of nonsense and now we're sitting here and now we're having to pick up the pieces. I'm somebody who accepts a decision of this type, but I think Mr. Batten made very clear that Germany is a net contributor, and Germany benefits from the single market, and so does the UK. But you can't calculate things that way. You can't say, well, we give, but if we have solidarity, then we have to have mutual respect as well. And what about all of the criticism and attacks of Polish people? Because it would have been important to resolve the situation. And we need to be fair with one another, and fair means also after Brexit that we're looking for mutually beneficial solutions. And I would like to say that it's not the EU that wanted to have a hard Brexit. That is a tone that was set by the British government. I have to say that quite clearly. And I think it's clear that the EU has to react with caution. I mean, if we are slapped in the face, we're not going to hit back, but we are going to be cautious. And I think that we would all be very happy if we could have constructive negotiations, and but a cherry picking simply not going to work.
Thank you very much. Before returning to our guests, please allow me just a couple of very brief comments. First of all, I'm sorry that our colleagues, Mr. Button and Mrs. James, left, because I think that the tactic of throwing the stone and then running away, it's not a good start for a dialogue or negotiation process. Secondly, I think it perfectly makes sense to have the panel, and I very much thank to all the experts and the petitioners that presented today a situation. It's not that they were biased, they just presented a reality that we have to deal with, because we all agreed that what is the most important is indeed the protection of people, not only EU citizens living in the UK, but also of the UK citizens living in the European Union. So it's not biased, it's just listening to the reality. But then when listening to this reality, I was struck by something. We, for good reason, look at the walls made of concrete and of bricks that are now building in the world. What about these walls? Legal walls, moral walls, practical walls. I really had a very, very sort of a scary feeling about the reality we are living in. So we go now to our guests exactly in the order that they spoke. I will first give the floor to Guy Verhofstadt.
Very short. The lesson that I have learned today, but that is only confirming what I thought, is citizens first. Let's start the negotiations immediately. Let's try to conclude an agreement. Let's make that agreement then public, so that the uncertainty disappears for everybody. And then later, that agreement can be taken on board as a chapter, citizens' rights in the withdrawal agreement. I see it like that, so that you don't wait until 2 years to say, oh, yeah, and now we have also a chapter on citizens' rights that we negotiated in the beginning. I think that is the sequencing that could solve the problem and create immediately from the conclusion of an arrangement certainty for the citizens. That's my first lesson. My second lesson is that I think, Mr. Morales, that it could be good that we prepare this resolution together with the COP and the Brexit Steering Group and your committee and the Employ Committee by the beginning of September, because then we're going to know what are the political elements that we have to put in it. So it will be not necessary to repeat what we already said in the previous resolution. That is not the purpose or the goal of this second one. Has to be on creating the necessary pressure on the points that we want to be in the final agreement. So I think that could be a good moment and to have that as a goal. And August, beginning September, I see that as the moment where we need to have a result on this issue. Otherwise, we don't create the certainty. And then 3, I should have a suggestion. You know, paragraph 27 of the resolution of the European Parliament. It should be good that Libe is looking also into that. I have sent it to Commissioner Jourova and to the Commission service in general to look to it. The same to the Council. But I think that from all sides also that we need to examine it and to see what legal possibilities there are. And some interventions that have been made this afternoon on showing that we have huge possibilities to do something in that field. So, but that seems to me also a point that the Libe Committee in the coming months could take on its plate.
Thank you very much, and I'm turning now to the panelists. No longer than 2 minutes each, please. Ms. Donskoy, please. The floor is yours.
Well, we would like to thank the panelists and the guests very much for the opportunity to be able to put forward our case. We very much welcome what was said today. It gives us some hope, and we do look forward to the resolution, which hopefully will indeed come as soon as possible early in the autumn. And I would remind kindly all the negotiating parties and all the committees to involve us as much as possible and be a constant, regular interlocutor in this dialogue. This has to be a dialogue and not just a one-way system. So thank you very much.
Thank you very much for all your contribution to this debate. Mr. Dörfel, please.
Again, I'd like to thank you very much for this panel. And just in relation to what the gentleman said from UKIP, I don't think we are all of one opinion either. I think what this shows is that there are so many issues to be resolved. And when we're talking about 4.2 million, we're already not registering the UK nationals that have exercised treaty rights and are back in the UK, the Surinder Singh cases, whose families will also be interrupted immediately the moment they don't have EU rights anymore. And from there, it goes on to people who may want to exercise treaty rights, and both on the UK side and on the EU side, including, of course, even for temporary purpose. So I think we're looking at a huge loss that can't just be circumscribed to the 4.2 million. I think there are so many, and I just hope that in the negotiations, it's all those groups that will be referred to and will be raised. So I think the issue about the European citizen as an inalienable right is a fantastic idea and a huge, enormous hurdle. So I'm also someone who hopes that the madness of Brexit is going to stop before it actually comes into effect. And the issue that was raised, I think, by business is saying, oh, can we have really long times to then get used to the changed position, shows this madness as well. Because the point is that you can't then have years and years and years to unentangle what's been created. And in terms of families, you can't unentangle because they will have commitments in the UK, children that go to school, they will have elderly relatives that are abroad that ought to be able to join under EU law but might not be able to do so. So you can't disentangle those. Thank you very much.
Thank you. Mr. Jeffrey, please.
Thank you very much. I have little to add. We've heard some powerful arguments. What I have is 3 hopes for the negotiation process, which will be difficult and complex. The first hope is that those negotiations are grounded in evidence, as much as a charged political process will allow. Secondly, I hope they go forward pragmatically. There is common interest, there is mutual interest to be won. It may not be a situation many would like to be in, but there is still mutual interest to be won, so be pragmatic. And thirdly, and that's the big lesson from some of the testimony we've heard, let's hope that the negotiations remain humane and remember that whatever the big economic calculations, the big strategic calculations, whatever else may be in the negotiators' minds. We're also talking about people, their lives, their opportunities. So evidence, pragmatism, humanity, that's all we need.
Thank you. Yes, Ms. Onslow-Cole, please.
Thank you. I just really wanted to say, I think it's very easy, particularly when we're having a debate like this, to stress the differences and the problems that there are. But actually, I think it's important to remember that underlying this, everybody really wants a resolution of this situation. And I think everybody recognises the importance of the issue and the absolutely fundamental importance of coming to as early agreement as we can. And I do think that if you strip away some of the issues, you know, it is hopeful that there is so much on both sides that, you know, is moving in the right direction. And I still feel very strongly that there will be a very positive resolution for all parties.
Thank you. Mr. Portas, please.
I agree with I agree with both with what Charlie just said about evidence, pragmatism in particular, and humanity, and what Julia said about there being a broad political consensus across the spectrum, despite perhaps one or two of the interventions we've just heard, that in the UK as well as in the EU27 to resolve this issue on a sensible basis. I would like to state that, despite what was said, I did not take a position either for Remain or Leave in the referendum campaign. My job is to present the evidence and analysis as I see it, and that's what I've tried to do today. I would say that, Brexit, assuming that Brexit does go ahead, and that seems to me to be the most probable outcome by far, again, despite what some have said, this will lead to the changes to the status of EU citizens in the UK, UK citizens in the rest of Europe, and to some extent of all of us in respect of potential rights, at least. That is simply a fact, whether we like it or not. Our job is to make that, to achieve that in the most sensible way, sensible, pragmatic and humane way possible. And there I would say that what can this Parliament contribute to that? I think two things. First of all, transparency and openness are good not just in themselves in this context, but because they will increase that political consensus in the UK and elsewhere to resolve this sensibly. The more you can be clear about the evidence, about what the propositions are on the table, about what the issues that need to be resolved, and put forward sensible and pragmatic possibilities for resolving those, the more there will be a political consensus, an economic consensus in the UK that will make it, that will put pressure on all of us to resolve this in the most sensible way possible. Thank you.
Thank you.
And before, before giving the floor to our two petitioners, I'd like you also maybe to reflect on how can we undo in a couple of years something that has been done in 4 decades. Ms. Benshaw, please.
I just want to say thank you for letting me come today and for listening to me. I hope it's made maybe a small bit of difference in the Brexit negotiations, and I just want to wish everybody good luck. Thank you.
Thank you. Ms. Wilkinson, please.
Thank you very much for having organised this event, and I'm so glad to have been able to participate in it. I've learnt a lot. It does trouble me to hear words like sensible, pragmatic and humane being attached to the conduct of these negotiations. I hope they're right. Thank you.
Thank you, Renata. Thank you all. I didn't want Miss Banshaw to speak again because I was pretending not to wipe away a tear. I was sort of itching my eye, and a few others were doing that. I really want to thank the speakers. Intellectually, morally, emotionally, it was really of the highest standard. I would also like to say to my MEP colleagues, the standard of questions, contributions were really of the highest quality, and people have to go, so I just want to say to Guy, and really from the suggestion also of Sophie, that we will follow this up in September. And to do it, we will keep, there is a task force at the core of all of this, and I really want to give credit to those members, and if I may say so, remember this is a very all-party issue, and I'm very impressed by the contributions of all my colleagues today, that we really keep in touch. There are some very deep issues when, Mrs Lambert mentioned social security. There are some gaps in our knowledge too. So we really need to stick together and work towards the September date, Guy. And we promise as three committees, but also the others when relevant, we'll work towards that date. And next time it will be even more focused and we will have the ability to make a difference. Thank you very much.